Your Lordship.
I beg
Greatly
pardon,
obliged.
my lord, item 85 of supplementary list. I've taken the consent of opposite party advocate, my lord. So I want to adjourn the matter on next week on any date, my lord.
Let's see when it comes.
Yes, my lord. Yes.
I beg pardon, my lord. Item 65, my lord. In view of the order of the Honorable Supreme Court, the Flipco case, my lords, I have filed the revised turn one. So this matter will be withdrawn, my lord, with the liberty, my lord.
Or
Obliged, my lord. 65.
that's it's liberty to file a petition to this law. This post office withdraw with liberty.
I am appearing for the department in this.
Old matter item number 1.
I'm for the opinion number 6. Item 1.
Item 1.
In this matter, your personal lordship's direction, we have filed our counter. Yesterday, counter was filed, but that is not brought on record. However, I have also got the hard copy, if your lordship. And I,
How is this matter directly before a division bench? How is this a division bench matter, sir? This execution, it's not challenging any order of the tribunal.
Yes.
Why is it a DB matter, sir? You should know.
I'm for opinion number 6, my lord. Instead of challenging before the tribunal, he has filed the case before
Who's for the petitioner?
Petitioner non-appears, my lord.
Oh,
nobody is there.
all right. All right.
2012, it was division bench matter. Later on, it has become, it has come to single bench by way of amendment, corrections.
What do you say in your affidavit, sir? Let's see that. Manufacturing official documents. Your stand is that she's manufactured official documents.
Yes, my
Enable
lord,
her to continue as teacher.
yes, my lord, that yes. She has not never been again appointed, but that there was no such resolution. I have annexed all the copies of the resolutions.
No, I wanted to know the current status because there was a status quo ordered with this court.
Yes, my lord.
And what was her age and did she continue as Hindi teacher throughout?
No, my lord.
No,
my lord. She after her termination and appointment of the present opposite party number 6, as she claimed that she was taken back. In fact, she was never been taken back and she is not continuing.
Oh, I see. Counsel for the School and Mass Education handed over a counter affidavit today in court. None has appeared for the petition. Paragraph. Counsel for the Mr. Mahapatra, counsel for the SNME department, informs the court that the petitioner never continued as Hindi teacher. And even when the status quo orders was passed with the court, was not continuing as such. Paragraph. The petition is dismissed for non-petition.
Item number 2.
My lord, on behalf of Mr. Rai, he's on.
Counsel, the petitioner is stated to be in some difficulty today.
Obliged.
Other sub-item, Lord,
So the sub-item actually, if your lordship grant me, today I am filing rejoinder. One set of rejoinder will do for all the 3. I'll file today.
What is the matter? If you people are ready, then we can take up Mr. Rai's matter later.
So let me file the rejoinder because they have taken some factual aspect also in the counter affidavit. So that any short date, if you're not seeing fixes, I can, because this is section 10 assessment.
Sorry?
Escaped assessment.
Oh, I see. Hmm. Hmm. Hmm.
So subsequently, by the proposal objection
Hmm.
and advance making
Hmm.
decision of the tribunal. That was followed in this case, reopened the case.
All right.
Saying that the chips and all that was crushed.
Hmm.
So gold
Hmm.
to become minerals.
Hmm.
So mineral is one of the entries in it.
Hmm.
So, on technical ground, it can.
One rejoinder will do to all the.
No, in one of the one or two cases, you have taken the change of change of opinion.
Change of opinion. This is the change of opinion. Escape assessment.
See, rejoinder to be filed. In other matters, you say rejoinder to be filed for the next date. Interim orders to continue. List on. April 19th.
Item number 3.
My lord, in item number 3. Or deeply.
In item number 3, we are challenging the order of the Sestat in Annexure 1, who has waived all the service taxable items, my lord. But the notification, my lord, may kindly turn to page 8. Have given that notification, mentioned that notification, CBSE by circular dated 2/32/2006, dated 12/11/2007. Site formation and clearance, that is para F last. Site formation and clearance, excavation and earth moving and demolition services. And G, for that in the instant case, the site formation, clearance, excavation, earth moving and demolition. All these are taxable under service tax, my lord. But the learned Sestat has waived all in all items, saying that is mining and
But it's all incidental to mining only.
my lord.
Then?
No, my lord, these are post mining. CBSE Hyde circular dated has also clarified that handling transportation activities are post mining activities and are chargeable to service tax under the relevant taxable service. Our notification is dated 12/11/2007.
Let us see the notification.
Where is the notification, sir?
12/11/2007.
Show us the copy, sir.
I don't have a hard copy any short time.
What is all this, sir? You're arguing a matter, you should have.
And
the
I'm sorry, my
notifications.
lord, I have just got it.
Now, on the basis of circular, we cannot.
Extremely sorry.
At the request of counsel for the appellant, who needs time to produce the relevant circulars and
Yes.
notifications. List on 20th April.
Item number 4.
I may pardon, my lord. Item 1, that is this. I have a comment dismissed for non-proceedings.
It's all over, sir, now.
Mother held up a lip rustler.
You tell all the others, sir. He's here.
My
What
lord,
about the other opposite party number 6? You have to tell him.
proceeding not appeared, my lord.
No.
He was appearing.
I appeared,
You
yeah.
were not appearing, he was appearing.
My lord. My
It's all
lord.
right.
Yeah.
So you find him and then we'll take it up. Yes.
Item number 4.
My lord.
My lord, here in this appeal, the appellant is challenging the charging of penalty, my lord.
My name has not been reflected in item 3, my kind.
All right.
Or else I'm missing in the cause list.
Certainly, sir. We'll definitely do it. All right.
Oh, bless.
Please carry on.
Yes, my lord. Here the disputed period is 1/3/2007 to 3/3/2008. My lord, the act, the Service Act included in the Finance Act with effect from 1/6/2007, my lord. And so far as this case is concerned, before service of notice, the appellant has already deposited the tax along with the interest. It is an admitted case of the department also. And my prayer in this case that whether the appellant was aware that he has evaded any tax, so far as the penalty can be imposed. Kindly see the substantial question at page 12, my lord.
What are the facts, sir?
But facts is here, the appellant is a mining contractor, my lord, and period in 2000, the service tax has included in the mining act, my lord, came into effect from 8/3/2007, my lord. And thereafter, my lord, he did not get it registered because honor of the fact, my lord, and and after that, my lord, before initiation of the so-called notice, my lord, after knowing the fact, he came to know he has already deposited the entire tax along with the interest, my lord, and he has get it registered on 4/3/2008, my lord. So far as the commissioner view was that ignorance of the law is not a.
What is the penalty amount?
17,78,000.
There was no stay granted, I think.
Already deposited. I think the before filing of the appeal that has to be deposited, my lord.
No, it has or should have or what? Are you sure it has been deposited?
So far as the that has been deposited, my lord.
When, sir? Here the
I have no date, my lord. I will take instruction.
Do that. Constable, the appellant needs time to ascertain if the impugned penalty amount has already been deposited and to produce proof of such deposit. 24th April.
Meantime, if the appellant will serve a copy on the department, then.
All right.
Item number 5.
There's a memo copy. Dismisses with liberty to file a fresh petition if any cause of action.
Item number 6.
My lord, petitioner is a small farmer, my lord, not getting crop insurance of the year 2018, my lord. Kindly see page 11, my lord. He deposited the premium.
All right, the petitioner's representation, bracket annexure 3, shall be examined by Principal Secretary.
Page number 2, my lord.
No. Who is Bank of India?
The person pending before page number 2, my lord. My reparation answer 3 is pending before page number 2, my lord.
Bank of India, it says. State Bank of India. How can we entertain writ petitions against State Bank of India now?
The branch manager, Diptipur State Bank.
It's crop insurance of which year?
2018, my lord.
Right. Opposite party number 2. And a reasoned order shall be passed thereon, not later than 1st March 2023. And be communicated to the petitioner within a week thereafter. Court clarifies it is not expressed any matter.
Press admission item number 7.
Your notes, may I please notes. The Vice of Entry Tax Act is challenged. It's covered by the Honorable Supreme Court's order dated 28th of March 2017.
Right.
I've just given the order. Honorable Supreme Court. It's a division bench judgment following this 9-judge bench.
In view of the judgment dated, order dated 28th March 2017 of the Supreme Court of India in civil appeal number 6474-6798 of 2017, bracket State of Orissa versus Messrs. Reliance Industries Limited. The presented petition is dismissed.
Much obliged.
Item number 8.
My lord, I am waiting for the petitioner, my lord. My lord, similar matter, your lordship have already issued notice. That is in WPC number 28599 of 2021. That is a lead matter. And fixed for 25th April, my lord, 2023.
List on 25th April along with that petition civil number
WPC number, my lord, 28599 of 2021.
28599 of 21.
I've already filed the counter. I saw a copy in the.
All right.
Item number 9.
I have prepared a small date chart. Here, the petitioner has a proprietorship business have 2 registrations. One registration is for crusher business and another for works contract business. That is under the GST Act. And we have that is 17/2017, that crusher business, that registration, that last digit is F. And that is another registration 15/9/2017, that last digit is E. And one is under the state and other is under this center. So the opposite party number 1 issued the notice on 29/1/2020 that directing to deposit the differential amount that is relating to works contract. But the state is under the state, my crusher business is there. And under the center, that works contract business is there. So 16/12/2020, they issue another DRC1. DRC1 that is so-called notice. And in response to that so-called notice, I have filed a reply. And kindly have a glance to so-called notice, how they are issuing this, that page 36. That date which reply has to be submitted, that is 25/12/2020. Notice was issued on 25/11/2020. But date of personal hearing is 15/12/2020. That before submission of the reply, they have given the date of personal hearing. And subsequently, I filed the reply. And after lapse of 2 years, that reply was filed on 16/12/2020.
No, this order dated 3rd February 2022.
My lord.
It's an appealable order.
My lord, that is appealable order. But here what happened, that works contract business is with the state. And center has, crosser business with the state and works contract business with the center. And in the meantime, I deposited the tax to the center. They have discharge certificate. Kindly have a glance at serial number 9, that 4722, in response to because I have discharged, because I am giving annexure 11. Kindly have a glance to annexure 11. Center has already given the discharge certificate. I have deposited total entire 2.7 lakhs rupees. That is on annexure 11, page 58.
You're not answering the question, sir.
But this is appealable. But here I have already discharged the tax, and they have not given me the personal hearing. I have filed the reply. If they have given the personal hearing, I have shown this thing to them.
You can take the ground of the appeal, sir.
No, my lord, I have already deposited 2.7 lakhs, and apart from that, again, I have to deposit for this arbitration agreement, I have to deposit another 10.
Petition is not the forum for avoiding all pre-deposits, sir.
No, I am not avoiding. I have discharged the tax, totally discharged the tax.
Explain that. We'll see what happens.
So kindly have, just I'm giving you how they have not issued not given the personal hearing. Kindly have a glance to 75/4.
That is the ground of the appeal, sir.
That may be, but this is purely violation of natural justice. 75/4, they have to give me the personal hearing. And kindly have a glance how they have issued the so-called notice and date of personal hearing prior to that.
And apart from that 75 force, anything going against me, they have to give me a personal hearing. When they're passing in, kindly have comes to 75-4.
Carry on, read it, sir. Read it.
My lord, an opportunity of hearing shall be granted where a request is received in writing from a person chargeable with a tax or penalty, or where adverse decision is contemplated against such person. So I have in reply, I have asked for a personal hearing, and apart from that, they are going against me, they have to give me a personal hearing. And after 2 years, they pass the order. I have submitted the reply, and after 2 years, they have passed the order. And in the meantime, I have discharged the total tax.
All right. Inasmuch as the
My-
impugned order
my-
dated
my-
3rd
my-
February
my humble
2022
my lord.
is an appealable one. The court is not inclined to interfere at this stage, permitting the petitioner to avail of the said remedy in accordance with law. The petition is disposed of. You filed any original, sir?
No, my lord.
All right.
So delay might settle her.
If the appeal is filed not later than 1st February 2023, accompanied by an application of condonation of delay, explain the delay on account of the pendency of the present petition, it will be taken into account by the appellate authority in accordance with it. The court clarifies it is not expressed any view on the matter.
My lord, I am appearing for opposite party number 3 and 4. Supplementary list item 10.
May I please, my lord, this is covered by case of automobiles. 6431. 6431 is case of automobiles. 6432 is anti-tax, SMAC.
ECMAS receipts. All right.
My lord, only the record, the order sheet has been maintained.
But
May be made, my lord.
That's it. It has to be communicated. The original record has been produced. The noting on the noting of the you see the order passed on file on 5th August 2013 records the acceptance of the self-assessment under section 39 of the Orissa Value Added Tax Act 2004 (OVAT Act). But there's nothing to show that this was communicated to the petitioner SSC. Paragraph. That view of the matter, the court case is covered by the decision of this court in Keshav Automobiles, which has been affirmed by the Supreme Court in Rati States. The impugned assessment order and all proceedings consequent thereto hereby quashed. In 6432, you say in view of the decision of this court in ECMAS Resins, give the citation. The impugned orders and all consequential orders, demands pursuant thereto are hereby quashed. The petitions are disposed of.
Your Lordship.
What does it still survive, sir?
Does still survive, Your Lordship.
How?
Because the original interim order is passed in the original rate application is pending, my lord. During pendency of the writ petition, now the authorities have stopped the wages, my lord. And the contempt filed during that period for violation of the 2013 order, my lord. For a period they paid, now they stop the payment, my lord.
Where is the writ petition is pending? The division bench.
As a single bench, Your Lordship. Now it is earlier it was division bench. Now this the assignment is becomes a single bench, Your
So
Lordship.
this also is to go there only then. It is stated that the assignment concerning the original writ petition, order passed the original writ petition, is before the roster bench of the single judge. List this application before the roster bench of the single judge. On 20th February.
Both 14, 15,
Item 15 also.
Same.
Item number 16.
I am pardon, my lord. I may pardon, my lord. Item 1, my learned friend has come.
Not like this, sir.
No, after launch.
Whatever. Yes.
Item 16.
Item number 16, Your Lordship, I am serving copy to Mr. Chimankar.
Yes.
And I will and I undertake to remove the defects within 7 days.
Yes.
And Your Lordship, the matter may be listed on 2nd of January. It's an old matter. I haven't prepared, Your Lordship. It's 2nd of January. I'm serving copy now.
I'm not sure, sir. What is this? Not tell us.
Lordship, it relates to
Some deficit court fee of 150 also, which you have not paid.
it relates to refund of Senvet credit. My initial application was allowed by the Assistant Commissioner, then on, it was rejected, then on first appeal it was allowed. And against that order, the department filed an appeal before the tribunal, and that appeal was allowed. Hence, against that order, Your Lordship, if Your Lordship may at least grant me at least 7 days time, Your Lordship, I will prepare and satisfy Your Lordship completely on this issue. It came up suddenly, Your Lordship, and
How sudden, sir?
question of Monday at least, Your Lordship.
Unfortunately, sir, we've arranged a board. We've got lots of matters on Mondays and Tuesdays.
Then any day Your Lordship wants.
One adjournment is a matter of right, always.
I'm extremely sorry, Your Lordship, but
So this is about a rejection of your refund claim.
Yes, my lord.
Refund is allowed only in those circumstances where a manufacturer or provider of output service is not in a position to utilize the input credit. So you're not doing only export, you're doing both manufacture, local manufacture and sale, as well as export. In a common credit. Counsel the appellant seeks an adjournment to remove all the defects. The defects we removed within a week. List on 6th April.
Item 17.
17, same, my lord.
All right.
Supplementary list item number 18.
My lord, 18 and 19 are analogous. Our appeal is at 18. Their appeal is at 19. It is partly allowed by the SESTAT. We challenge the partly allowed.
My lord, so far their appeal is concerned, we have not received notice till like, my lord.
My lord, may it come, I will seek some instruction. It's a transfer brief, my lord. In both the cases, I will seek some instructions. So, my lord, may kindly be pleased to allow me time.
Yeah. First, put down his name. That's the main prayer always. Please put down his name.
18 and 19.
At request of Mr. Panda. Both these are adjourned. Put both the appeals together.
My lord.
Both these appeals are adjourned.
The same 28th
April. Interim orders to continue.
Item number 20.
20, my lords, I'm appearing for the appellant. My lords, I'm praying for a week's time to remove the defects. Also, my lords, it is my knowledge that the respondents, my lords, there was CIRP proceedings initiated and respondents. So I have to take up-to-date instructions. What is the fate of the resolution plan, my lords? If the present appeal has been concluded, I'll need instructions regarding that, my lords.
At the request of counsel, the appellant who needs time for instructions. 26th April.
Grateful, my lords.
Item number 21.
My lord, 21 may be taken up by other bench as my lord Justice Roman is concerned.
For a bench of which is Roman is not a member. On 24th April.
God bless. Item 22.
22 state is the applicant. What has happened, my lords? It is in time. Writ appeal was dismissed due to non-appearance of the pleader. In writ appeal state was the appellant. Lordship may hear the
2010 appeals, sir.
in the writ appeal, the impugned order of the Honorable Single Bench is directing the representation to be disposed of in the light of a particular decision. We say that that decision is stayed in the Supreme Court. That night, that writ appeal may, because the writ appeal was dismissed due to non-appearance of the government advocate. If your lordship will restore it and dispose of the writ appeal,
The whole thing is gone for a toss, sir. You're considering the representation. You could have easily said this order is stayed. Why do you need to file a writ
yes,
appeal for
that could have been, your lordship is correct.
No need. This will now go back and then again an order has to be passed.
May I pray one thing, that you may restore it and pass necessary orders in the writ appeal itself, whatever is, because the state appeal was dismissed for default. The impugned order is 25th. April 2009.
What's the delay?
WPC 25th March 2009.
477.
In the writ appeal, which delay is the initially miscase was filed, it was again converted to CMAPL.
136. So writ appeal was delayed. Writ appeal is delayed by how much?
Writ appeal was yes.
But it was delayed by 477 days.
There was delay in filing of
Writ appeal itself. You see, there is a delay in
2009.
filing. There's a huge amount of 477 days in filing the main writ appeal itself, which was dismissed for non-prosecution. Consequently, the question of entertaining the writ appeal did not arise. There will be no purpose served in entertaining the present application, which is accordingly dismissed. The contempt case will now be placed before the roster bench of the single judge for directions on 9th January 2023.
My lord, may I request, my lords, some long date so we can instruct them to comply the order in the meantime. 9th February.
13th February.
Applies.
All right.
Item 23.
23, my lord, same, I think, same thing.
All right. The delay in the writ appeal is so much. Must be again 400 plus days. Hmm. 477 days. All right. Same order. All right.
Both the cases are filed on the same day.
Item 24.
24, my lord, same prayer, last mistake. Dismiss for default,
Delay here again, see.
passed any order in the appeal manner, maybe restored in the past manner. Same prayer, my lord. It's last fault.
What's the delay, sir?
CMAPL no delay.
No.
Writ appeal.
No stamp reporting.
Certified copy. Judgment is.
All right. You see, in the writ appeal, certified copy of the judgment is not placed in record, and accordingly, no stamp report could be prepared. In the circumstances, no purpose will be served in entertaining the present application to restore such a writ appeal. The application is dismissed. All right.
Item number 25.
My lord, item number 25, the matter was infructuous.
All right. Dismissed as infractions.
Item 26.
My lord, question of law is at page 22 of the revision petition. Roman 1, whether on the facts and in the circumstances of the case, the order of the Orissa Sales Tax Tribunal is liable to be set aside inasmuch as it ignored to take into account provisions contained in Section 9.2, read with Section 9.2b of the Central Sales Tax Act 1956. The next question is whether on the facts and in the circumstances of the case, the Law and Orissa Sales Tax Tribunal should have directed for payment of interest for delay in payment in terms of Section 9.2b of the Central Sales Tax Act 1956, read with Rule 8 of the Central Sales Tax Odisha Rules 1957, taking cognizance of the fact that the dealer had deposited the amount of tax as determined by the authorities below by admitting that it did not discharge its liability appropriately during the material period by furnishing declaration forms in order to avail concessional rate of tax. Yesterday, my lord had answered these questions in favor of the revenue. Item number, weekly list item number 11, that is STREV 36 of 2017.
That's disposed of.
Yes, my lord. But the order has not been uploaded.
No, we've allowed it, is it? Or just a notice returnable. 27th April.
I'm not 27.
Manner, please.
Item 28.
Your losses. This is the entry tax 2J losses, and your losses fixed the order matter 6/2/2022 hearing, my lord. Entry tax of
February 20.
losses. Question of law frame losses is page 6.
No, it's coming up on 6th February.
6th February.
Obliged losses.
Item number 29.
May I please? Yes, sir. I have removed the defect. Limitation is for 2 days. Saturday, Sunday, due to Saturday, Sunday, the revision petition was filed on Monday. I'm sorry. Whereas in this case, the petitioner, being a public sector undertaking, was supposed to sell his scraps through an agency, MSTC. MSTC, he is on his own invited bids, and after the successful bidding, he recommends the whoever will be taking the purchasing the scraps from the NTPC. If I will take your lordship to the annexure 1, annexure 1, page 11. That is a sale release order by MSTC. MSTC sale order NTPC, scrap yard, and it has been it will be sold to the agencies, Bharat Oil Agencies, turbine oil scrap. And based on this,
notice returnable 26th April. He accepts notice. Right.
Item 30.
The dispensing that is allowed. Defects were removed in the meanwhile.
Item number 30.
30, my lord. The question of law is that page 20 of the revision petition, my lord. Whether on the facts and in the circumstances of the case, Odisha Sales Tax Tribunal, or by reducing the imposition of penalty by applying the amended provision in section 43(2) by virtue of Odisha Value Added Tax Amendment Act 2015, which came into force with effect from 1/10/2015. Whether on the facts and in the circumstances of the case, the interpretation of majority of members of the Odisha Sales Tax Tribunal was correct to the effect that the amendment in section 43(2) of the Odisha Value Added Tax Act 2004 would apply.
This is not decided in any other case.
No, my lord.
All right. Notice returnable 26th April.
Item number 31.
Item number 31, my
He
lord.
is allowed.
31.
Item 31, my lord. The question of law frame is page 20, my lord. whether the fact and circumstance that single bench of judicial member Odisha Self-Tax Tribunal right in law to hold the goods that is sand, chips, dust, metals, and budgery are falling under entry serial number 59 of part 1 of the entry tax schedule and the consequential demand of entry tax thereon. The question number 2 is, my lord, whether on the fact and circumstance case, the single bench judicial member 1 Odisha Self-Tax Tribunal right in law to hold that the goods under
Same thing, sir. He's held them to be minerals.
Yes, my lord.
Not decided in any other case.
My lord, it is
already decided.
My lord, it is on 19th April and item number 2, today's item number 2, my lord.
It's already decided.
It has not been decided, my lord.
This batch is pending, but in the decay constructions case.
Decay construction not with relating to sand, that is with regard to ballast only, my lords.
Decay is not covered by. Decay is under the OST Act. These matters and item number 2 is under the Entry Tax Act.
All right. 19th April, is it?
My lord.
There is some variation in
the language
OST,
of the
OST entry tax entry and
the schedule of the entry tax.
Yes, sir.
List along with
25078 of 2017 WP, my lord.
WP civil number 25078,
my lord.
Of
2018, sorry, 2017, item 2 of today's list, my lord, subtender list.
Item 2, they have taken a decision, they have taken a stand of section 10 vis-a-vis section 9C.
But this part also been covered with that.
On 29th April.
19th April.
19th April. All right.
Item number 32.
Oblige, my lord.
I don't make kindly be taken up before any other bench. All right. This before a bench of Justice, which Justice Governor is not a member. On 25th April. No, not 25th. You say 26th.
26th April.
Item number 33.
My lord, I bring for petition, my lord. Arising of the common order, my lord, 2 petitions were filed. Yesterday, in the one petition, we also have already issued notice.
When is that coming
Same
up?
common order. That is coming up, my lord, on 27th April 2023.
All right. Notice list along with?
ST Rep number 19.
19 on 26th April. Right.
27th April, my lord.
27th. All right. 27th.
27th, my lord.
Item number 34.
Oblige, my lord.
Item 34. So entry tax matter connected to the Supreme Court decision on entry tax. It was connected to the batch of cases. I paid the entire tax. Only the penalty is to be decided.
Delay, sir, you always have to address the delay.
Millards? A delay.
Delay is 454 days.
Yes, yes. But actually, she is for that period, she was suffering from sickness and high diabetes. And her husband, Millards, though I could not write there, but her husband is suffering from abdominal cancer, Millards.
That's all. All this doesn't prevent you from just instructing a lawyer. It's a huge delay, sir. 454 days is almost 1.5 years.
I paid the entire tax. The penalty amount is to be decided from the date of judgment in Reliance case up to the Supreme Court's judgment for that period, whether penalty is payable or not. That is, these are all connected to the batch of cases, Millards, WPC.
Decided you can take advantage of that. What do you say?
Pradhan, Mr. Pradhan. Mr. Pradhan.
My lord.
What do you say?
400, so much delay, my lord. Our STRB has been rejected by my lords. The same ground.
I don't think they're doing anything to recover penalties. There's no stay granted in the last 3 years. Yeah, no stay was granted. I don't think they're doing anything to recover penalty from you.
No, Millard, sir.
So 5 years is 5 years is the recovery period for the revenue. So it is, I think, more than 5 years have been elapsed.
Millard, I have diligently paid the taxes, and the decision of the committee says that penalty should not be imposed for non-payment of withheld amount of entry tax if there is no suppression of turnover. There is no allegation that there is suppression of turnover or anything evasion of tax against me, Millard. So the only suppression of turnover should be dealt with as per law, and penalty should be imposed. After the Honorable High Court's judgment, Millards, everyone was under the impression that tax is not to be paid for that period. And then the
your annexer 4, your annexer 4 relates to 15-16. I think that is not the impugned period. 7 to 12 is the assessment period which we have impugned, but annexer 4 recovery of demand that relates to 16. The tribunal's order relates to 2007 to 2012.
7 to 2012.
Yes. But payment of demanded dues, recovery notice is for the year 15-16, which you have enclosed as annexer 4, page 23.
You can't recover. Correct.
If I look into it, it has come suddenly today after a long time. I will look into the matter. May Lordship may give me a date, Millards. I will prepare myself and come back.
Counsel, the petitioner needs time to prepare the matter. 27th.
Item 35.
States revision, my lord. The law is at page 30 of the revision petition. Question number Roman 1. Whether on the facts in the circumstances of the case, the tribunal is not correct in holding that the dealer opposite party had sufficient cause contemplated under section 7(5) of the Odisha Entry Tax Act 1999 for withholding part of entry tax 2/3 in respect of the tax period 1/4/13 to 31st.
Correct. Yeah. Correct.
We have decided recently. With
Yes,
regard
that
to
railway case.
Huh?
My lord has railway divisional railways case.
It's a senior divisional railway. Senior divisional railway.
Bona fide belief.
All right. We won't interfere, sir. The challenge by the state in the present revision petition is to an order dated 5th April 2019 of the Odisha Sales Tax Tribunal. In SC numbers 70-72 of 2017-18, whereby the you file only one revision petition against everything, is it?
My lord.
Yeah. So it's come only against 70 and 72.
22,
in a second bill number 70 bracket ET and 72 bracket ET of 2017-18 by the impugned order, the tribunal has held that determination of purchase value in the audit assessment was not permissible, as it was beyond the audit visit report. At the same time, the procedure adopted by the dealer in adjustment of refund amount of tax accrued against export sales by adjusting with entry tax payable is not in accordance with law. Paragraph. Having heard learned counsel for the state, the court is not satisfied that the impugned order be tribunal gives rise to any substantial question of law. Stop. Similar issues already been decided against the department by this court by its order dated -N-. The revision petition is accordingly dismissed. Same in 37, is it?
Yes, 37 and 38.
37 and 38. All right. All right. Put down all three in.
Item number 39.
None appears dismissed.
For orders item number 40.
40 minutes, no instruction.
No instruction.
Item 41.
You
41, my lord, I request your lordship to kindly take it up after lunch. I'll be highly obliged.
What's
No, my lords,
The conducting counsel is on leg.
let me submit it. Nothing will.
Because my learned senior is on his leg, so kindly take it after lunch, your lordship. He has requested.
Who is appearing in this?
Mr.
Who is appearing in this case? Mr. No.
In his.
In my case, Mr. Parvati
He is the main petitioner.
No, I am not the main petitioner. Main petitioner is the TIL, your lordship.
Let me submit one.
Subleshwari.
Let me 5 minutes, your lordship may hear me.
Yes.
I am giving the chart. How many cases are pending before your lordship and what are 8? The main case is 13241 of 2022. Rakesh Suna versus State of Odisha. The second item. In this case, my learned friend is appearing and he himself is.
What happened in the Supreme Court?
My lord, that is what I am saying. In this case, your lordship has passed the interim order, and this case prayer and the prayer in the case which my learned sister, the advocate has filed, identical. And that interim order was challenged by Rakesh Suna and others by my learned for the Honorable Supreme Court. Just now I got the information and got that the case was filed before the Honorable Supreme Court on 30th October, and till today he has not filed the annexures, defects not removed. And what I understand from Mr. Mahadev, after 30 days, it will be deleted, or 90 days, it is automatically deleted.
And as per my instructions, your lordships, today they are removing all the defects. I have taken the instruction in the morning. Today they are removing all the defects.
But today's status is this. What I beg that this is a developmental project for the Sambalai Mandir, and we are trying for a beautification of that area. Now they are admittedly, the land from which we are trying to evacuate the petitioners.
Problems will not, you even last time told us that because of the pendency of the present writ petitions, you're not able to do anything, correct?
Yes, my lord.
The same position will be there when because of the pendency of the SLP in the Supreme Court.
No, SLP is nothing. That is what I am saying.
If according to SLP, the pendency doesn't matter, then this pendency.
No, pendency is not there.
Once the interim order is vacated by this court, it should not worry.
But my respectful submission is that what I beg to submit, that what is their prayer? Prayer is that we will not take the compensation as per the policy formulated by the government. So they are entitled for more compensation. So my resolution, let the prayer, let this writ petition be there. I don't want that it should be finalized. But let the petitioners be directed to settle with the.
Why should we direct? This is not the direction they're seeking. What they're seeking is something else.
But
But when they are asking for X, we are giving Y. That's not the point.
But
In
question
fact,
is
we are
that
then answering, you're allowing some prayer of yours in their repetition.
no, but so far as quantum is concerned, that cannot authorize them to retain the unauthorized possession for indefinite period.
What we have to do, we have done. It's up to you now.
May I pray one thing to your lordship? Unless they get an order from the Honorable Supreme Court, I should be allowed to operate the evacuate them. Because they are doing law and order, they're creating law and order situation there.
So for our different problems, there are different solutions. We cannot find an answer to all that. This is only their petitions. This is not your petition, sir.
I don't, you'll kindly visualize the entire, otherwise the project, we cannot undertake the project within a stipulated period. We have to finish.
All projects are challenged. Various things happen.
Your lordship may kindly remember, these type of cases were also filed when we, this SCB medical project, Taladonda project, there are two, and your lordship, because of your lordship's kind indulgence.
No, but those petitions are not pending. They're all disposed of.
Now they are disposed of on that ground that you, if you are aggrieved by the payment, you can ask for more payment before the decision, and that will be considered in accordance with law. But what is the necessity of keeping the matters pending? That is my response submission. Because they are only interested for more amount.
See, the only thing is, if the Supreme Court, if in the SLP that is
and another
that will have a bearing on this, that's all.
We are also interested for resettlement also. We are not, everything we will adhere to, but they are only saying that reproduction is pending and the matter is pending, Supreme Court, everything by this, there is no end to this, my lords. Because otherwise we cannot do the work. This is a developmental work for them only. We are also consulting, constructing big market complexes. They will be shifted to that place. I pray your lordship to find out ways and means for the district administration, because we are also a part of the system for the benefit of the general public. We are doing, not that there is any vested interest of the government in this particular project. And in all over the state, your lordship will see, in all the big temples, works are already completed except this Samle temple, because of this interference of these people of that locality. Not the entire locality is in favor of doing the work, but some encroachers who are forcibly occupying the government land, and your lordship has already, they are not entitled for the compensation under the 2013 Act. So policy formulated by the government, whether that will stand or not, that will be decided in the writ petition. If your lordship will say, no, this policy, even if it is applicable to throughout the state, for Sambalpur, we are not entitled to enforce that policy, then your lordship can revoke it or direct us to modify that policy. But so far as the retention of the unauthorized possession is concerned, my humble prayer before your lordship is that they should not be allowed to do so. Otherwise, the district administration is a utter jeopardy.
Counsel for the writ petitioner, counsel the petitioner in writ petition civil 13241 of 2022 informs the court that the defects in the SLP filed by them in the Supreme Court of India are being removed today, and therefore the SLP will be numbered and listed soon for hearing. Paragraph. List on 31st January.
Item number 42.
May please, your lordship. And here the public notice has been issued by the collector Jajpur inviting objection for grant of onset. Prior to grant, my lord, here the Punch of the Gram Panchayat, he has given objections under Annexure 2 series and apprehending that there will be onset. And after issue of notice also under Annexure series 4 series, they have passed resolutions. Even then, my lord, collector is proceeding with the matter. The resolution has been passed by the.
Direct the collector that all objections pursuant to the format notice which are filed within time shall be considered in accordance with.
Annexure 4 series or in on time, in time.
Within time.
Within time.
Any objection that is going.
Annexure 4 series, not all are within time.
Issued to the collector Jashpur to examine all objections received pursuant to the notice.
Annexure 3, my lord. Annexure 3 format notice.
Annexure 3.
In form
Page 19.
Roman capital 8 bracket annexure 3. And take
Within time.
Yeah,
Yes.
which have been received within time, and to pass a reasoned order thereon. After hearing the objectors on or before 1st February 2023.
Obliged.
No further directions are called for the mention as disposed.
Item number 43.
No.
Item 44.
No, please dismissed.
I'm for the opposite side. Item number 45.
45, I pray for filing of this item. I have received counter. I will file this under.
All right, discharge to be filed before the next date. Defects also be removed.
Not should be short date because it is confiscation proceeding. I'll file within a week. I'll file within a week. Yes, interim order is there.
An interim order in your case.
2nd February, order cut.
Published.
Item number 46.
Item 46 and 47, I pray for 1 week time to remove the defects.
Okay, defects be removed within a week, list thereafter.
Item number 48.
May I please? 48 is the second round of litigation, my lord. The petitioner was granted to operate, lordship kindly see annexure 1 to operate a country liquor shop, West Main Branch shop, and the license was granted by the government of Odisha. A show cause notice was issued by the annexure 2 regarding the irregularity committed the petitioner, my lord. That order was show cause notice was set aside by this honorable court by the annexure 7, my lord. That because the procedural irregularity is there, page 34, annexure 7, the first show cause notice was set aside, which was issued by the excise commissioner, my lord.
But this collector's order is revisable.
No, I am not in the collector orders. Collector has not passed any order. You also kindly see, collector has rejected my representation. My whole ground is the collector is not competent to give show cause notice because this, as per section 20, the state government has the license. And as per section 5C, the excise commissioner has to issue the show cause notice, though in a previous occasion, the excise commissioner has issued the show cause notice, my lord. You will also kindly see annexure 3, page 26, which was set aside by this honorable court, that has been issued by the excise commissioner. And as per section 47, the licensing authority has to give the show cause notice, my lord. You will also kindly see section 47 of the Excise Act. Here in section 20, I am reading first section 20, my lord. Grant of exclusive privilege of manufacture and sales of foreign liquor, India-made foreign liquor, and country liquor or other intoxication. The state government may I read, my lord? The state government may grant to any person on such conditions and for such period as it may think fit the exclusive privilege. The state government has given me the exclusive privilege license for manufacturing of the country liquor, my lord.
My lord, annexure 3, page 26, the excise commissioner has fixed the date for hearing to 29.
That has been set aside. That has been set.
Oh, I am sorry.
On subsequently that, annexure 5 was ordered by the collector, and that has been set aside by this honorable court during the procedural period.
Now annexure 8 has come.
Yes,
followed by annexure 10.
Yes, annexure 8 followed by annexure 11 also, because my humble petition is the collector has.
We have only 10 annexures, sir.
My lord, no, my lord, 11 is there, my lord.
I don't know.
Your lordship, election page 52. Because what happened in this case, the collector has decided my application, but forwarded to the government to take a decision. If a person is not competent to take a decision, then how could he issue the show cause notice and decided my show cause reply, my lord? My show cause reply, your lordship kindly see on page 55, going through the explanation submitted vis-a-vis violation of relevant excise law, that implied knowledge of the license and her intention in committing the illegalities, the license of Balisara West Main Shop is liable for cancellation as provided under Section 47 Orissa Excise Act 2008, 249 of Orissa Excise Act 2017. Under this backdrop, the explanation of Srimati Sarojini Malliki being unacceptable and unsatisfactory has been summarily rejected. Accordingly, the proposal for cancellation of license of Balisara may be for the government. When a person is not competent to take final decision, how the show cause notice was, as per the Section 20 and Section 47, the licensing authority who has granted the license, he has to give the show cause notice.
He is not correct, I think. With you, collector is to take a decision on the allegations raised against him. But so far as cancellation of license is concerned, he will only refer the matter to the government. Government will take a decision based on the finding of the collector.
Section 47 specifically says, Section 47 for specifically says, the person who has granted the license, he is competent to issue show cause notice regarding cancellation. Then as per Section 5C, your lordship can see Section 5, appointment, power and functions of the Excise Commissioner. Your lordship can go to 5C to issue, suspend or cancel license a permit with regard to the liquor. Here is the question for consideration. As per Section 20, the government has given, even if the Excise Commissioner has no power, the Secretary has to give. The principal secretary has to give the note because Excise Commissioner is not competent to represent the government. Your lordship knows the secretary, the principal secretary has only the person who can represent the government. When we can file it. Another thing, when the collector has no power to pass the final order, how they issue the show cause notice?
And 1 minute, come to Section 47.
Yes, my lord, Section 47. Section 47, my lord. Power to cancel, suspend, subject to such restriction as may be prescribed. The authority, this is the main important, my lord, granting any exclusive privilege, license, permit or pass under this act may cancel or suspend it irrespective of the period for which it relates.
So who's this authority granting license?
This is the section, as per Section 20, government.
Government is the authority.
Then the collector has to issue the show cause notice, my lord.
But collector and government are different.
Yes, ma'am, because the government has to be, and previous show cause notice, moreover, previous show cause notice was issued by the Excise Commissioner, as per Annex 3, my lord.
No, but why is collector not the government?
My lord?
Why is the collector not the
Can the collector will represent the government, my lord? Because,
why not?
Because your lordship, the principal, no, the principal secretary has to be represent the government.
Why?
So your lordship for all over the state.
Because whenever we file a writ application, whenever even the action of the collector is under the challenge before your lordship knows, when we made implement the state of government as a party, that should be represented through the principal secretary, my lord.
Why can't?
Because the collector has, because state government has, the collector, as per Section 20, the collector has no power to issue. If that is so, then where is the power to, why the collector has not taken the final decision? Why it is necessary, there is no provision as such in the statute to refer the matter to the Excise to decide the final decision, to take the final decision. As per Annex 11, if he has rejected my application, he has to take the final decision. But he has referred the matter to the, if a person will hear the matter and another person will pass the judgment, your lordship can visualize.
There are decision, government is the authority.
This lord has held that government is the authority. Lot of decisions.
My lord,
judgment is there. 1975 Orissa is
Pradyumna Kumar Mahapatra versus state of Orissa, my lord.
If any district such an infirmity is found, the collector is the district authority. You will issue notice, you will file show cause, and if your show cause is found to be unsatisfactory, collector will recommend the matter to the government for appropriate action under Section 47. And that has been done. In the earlier occasion, since the Excise Commissioner did it, that is why it was quashed.
No.
It is.
My lord, no, that is not this. My lord, senior is not, because that has not been procedural irregularity. Most clear 7 days notice has been given as per Section 47. Because there is no provision in the statute. There is no provision in the statute how the collector will refer the matter. Kindly, lordship, there is no provision.
The secretary will issue notice to all defaulters throughout this.
No, that is the, because there is no provision. If the secretary will not grant, then there should be a provision. The collector will take final decision.
No, let's come back to 47.
Your lordship, 47, my lord. Section 47, my lord.
47.
Section 47(4) is 7 days clear notice. Subject to such restriction as may be prescribed, the authority granting any exclusive privilege license.
This authority.
My lord?
This authority is state government, correct?
Yes, my lord.
So the question come back to.
The authority is the state government. If the lordship will hold the collector is the authority of the state government, then my humble submission is why the collector will not take the final decision?
Cannot.
Why? Where is the provision to?
That is 47.
Where is the provision to recommend? There is no provision as such in 47. Your lordship kindly see 47(4). Before cancellation of the license, privilege license, permit or pass the authority cancelling, it shall give to the grantee at least 7 days notice in writing of his intention to cancel it and offer an opportunity to him to show cause within the said period as to why the exclusive privilege license, permit or pass should not be cancelled. Where is the provision to refer the matter to the excise commissioner to take a final decision? If a person is not competent to do this, how he will decide the matter and what remains to decide by the excise commissioner? When he has already rejected the show cause reply, what remains to decide the show cause, your lordship can see? What remains to decide Annex 11?
He is the approving authority.
No, he rejected, not approving. He has rejected. Language is rejected. Representation of mine is rejected. Then what remains to decide?
What has happened pursuant to that 16/9/2022 order?
Yes, my lord.
What happened pursuant thereto?
69, this honorable court order.
No, sir. The collectors, impugned order.
Yes, collector, first Annex 10, my lord. He has rejected.
What has happened pursuant to that order?
No decision has been taken till date. This is pending before the excise commissioner.
So whenever the excise commissioner issues the final order, you challenge that in accordance with law.
Here, final order means what remains to decide? Whether the lordship has to decide.
No, you say this is only a recommendation.
No, that is rejection, my representation, my show cause reply to show cause. The language is rejected.
You just now argued, sir, that he has no power to recommend.
No power to issue show cause notice.
That is one part.
Second part, like if he could have been, he has the power to issue show cause notice, he has to pass to final order.
So this is not, even according to this is not a final order, correct?
No, rejected. I am aggrieved.
Don't switch from.
No, I'm sure 11.
Keep arguing. This is not a final order.
This is not a final order. I have before your lordship to rejected my reply to the show cause. If the collector,
according to you, is this a final order or on this some other order has to be passed?
No,
there are two more steps.
No. Anyway, let's understand what according to him will.
According to him, I have to my lordship my first ground of challenge in this application that the collector has no power. If it could have been the power, he has to fight the final order. And in that case, the rejection of my show cause reply, considering the ground, this is not tenable in the eye of law. If he could have been forwarded the show cause reply to the Commissioner of Excise, then matter could have been.
You're not answering the question, sir. According to you, is this impugned order a final order, or according to you, on the basis of this, some other order will be passed?
Some other order will be passed by the Commission.
Correct. Because so that order, if it goes against you, you will challenge.
Another thing.
That order, if it does not go against you, what will you challenge?
What basis the Commissioner will pass order, Mela? What basis? On the basis of the show cause, when the collector has given a note, the rejection or rejected.
Will say that because you say it's not a final order.
Say
might be heard when the commissioner passes a further order.
Your lordship may say my reply to the show cause will be independently dealt by the commissioner.
That cannot be.
Why not?
It has to be dealt by the collector.
Why?
Commissioner is the appellate authority.
Power of the collector.
He is the appellate authority.
No.
You go and appeal.
No, you have wrong conception.
You put for it's not at all wrong conception.
My lord senior is the wrong. Your lordship may direct the commissioner will decide my reply to the show cause independently. Because there is no power again.
He is the appellate authority. He is the appellate authority.
Your lordship, there is no power as such the collector. If a person
has no power, that is why the order is not sustainable in law.
Your lordship may say, section 5(4) also, the state government for the whole or any part of the state or in any district may appoint any person, whether there is notification of the sub-collector. Your lordship may section 5, subsection 4. The state government for the whole or any part of the state or any district may appoint any person or officer to exercise all or any of the power and to perform all or duties conferred or imposed on a collector by under this act, subject to such control as the state government may direct. Where is that direction, my lord? Is he authorized? Whether there is any notification regarding the collector competent to pass such notice? He cannot, because as per section 20, government is the granting license. And as per section 47, the authority who has granted license, he is competent to do. Only the state government.
May I pray one thing, suggest one thing to your lordship? Let the petitioner be directed to appear before
That's
the
all.
excise
We'll
and raise
go to
all
that.
the issues,
Yeah.
whatever he is.
Correct.
Another thing, there is no cancellation order, but my shop is closed since long, despite the order passed by Honorable Court, since 8 months.
That's a separate thing, sir. That's a separate.
So another, your lordship.
That's a separate thing.
That is a separate thing, but I have suffering, my lord.
All right. The challenge in the present petition is to a show cause notice dated 8th August 2022, followed by an order dated 16th September 2022, both by the collector Ganjam. By the impugned order, the collector Ganjam has, while rejecting the explanation offered by the petitioner pursuant to the notice issued, placed before the government in the excise department proposal for cancellation of the Balisira OS shop,
main shop,
in the respect of which license was issued to the petition. Paragraph. Learned counsel for the petitioner urges that both the show cause notice as well as the impugned order are without jurisdiction, since, according to the petitioner, the authority that is empowered to cancel a license under section 47, read with section rule 240, section 47 of the Orissa Excise Act 2008 (OE Act), read with rule 249 of the Orissa Excise Rules 2017, is only the government of Orissa.
249 in respect of the wrong provision is quoted. That is in respect of molasses, but this is the country liquor, my lord. 249. You lost 249 regarding the part 3.
Only act.
Is the OS, my lord. Out still. 249 in respect of the molasses. Even if collector has not exercised his judicial mind, they did in 249.
Where do you get in 249 that is only
molasses, my lord? License and your lordship, part 3, license and permit for of molasses, my lord.
I see. All right. All right. That remove that rule for 249 can only be the state government and not the collector. Yet, even according to counsel of the petitioner, the impugned order is not a final order, since it is only in the matter in the form of a proposal to the state government for cancellation of the petitioner's license. Paragraph. Since even according to the petitioner, there is one more step in the form of commissioner in the excise department having to act on the proposal of the collector. The court is following directions. 1, if not already passed, the excise commissioner will, on the basis of the impugned order dated 16 September 2022 of the collector Ganjam, pass a final order after hearing the petitioner on a date to be informed to the petitioner at least 1 week in advance. 2, it will be open to the petitioner while appearing before the commissioner to urge all the pleas urged in the present petition, including the lack of jurisdiction of the collector, to issue the show cause notice or pass the impugned order. 3, the court clarifies it has not expressed any view on any of the contentions.
A petitioner be directed to place the order before the commissioner for compliance.
The petitioner will now appear before the commissioner along with a downloaded copy of this order on 16th January
And your lordship,
Any
2023.
short date, because in the meantime, they may take in any short date, they may at least appear
first week of January.
All right, on 4th January.
Lordship, may direct to conclude the proceeding
Yeah,
within
the
stipulated.
commissioner will pass the final order within a period of 4 weeks thereafter.
Okay.
The petition is disposed of in the above terms.
Item number 49.
Hello, this is an appeal arising out of the impugned order at Annexure 13, page 40, my lord. The issue in this case, the short issue rather, to be determined in this case, my lord, is whether the appellant is covered under the notification number 43/97, appearing at 18, page 18, my lord, which exempts from payment of service tax to certain categories of persons. And in those cases, the liability to pay service tax will be done by the recipient of the service. In this case, my lord, kindly refer to notification number 42/97 at page 17.
Yes.
By this notification, the goods transport operator service was brought into the service tax net with effect from 16 November 1997. Thereafter, my lord, a notification was issued 43/97, where 8 categories of persons were liable to pay service tax, and other than those 8 categories, service tax is not payable by the provider of service in that case. The Annexure 5 to the memo, my lord, is a clarification on notification number 43/97. Here, in paragraph 3, the government of India clarified that in respect to the first category, namely factory registered under the or governed by the Factories Act, the liability to pay service tax remains unchanged. However,
1 minute, sir, before you proceed, what you're challenging here is the 9 September order of the Commissioner Appeals.
No,
A tribunal.
Tribunal. Annexure 13, my lord, page 14.
Right.
So, by this clarification, the government of India clarified that the factories which are registered as small-scale industries, the service tax shall be kept in abeyance. Subsequent to this, on keeping in view the decision of the Honorable Supreme Court in what is that? Laghu Udyog Bharti case, the Supreme Court held that the amendment to the rules made in the service tax rules, the government has no power under the statute to make the recipient of service as liable to pay service tax, the persons liable to pay service tax. Keeping in view this decision of the Supreme Court, the notification number 49/98 was issued. Since the government didn't have the power to nominate recipient of the service as the person liable to pay service tax, the entire
notice who's accepting.
Lord, I'm there.
Notice he accepts.
I've already entered appearance. Counter has been filed, my lord. I've served copies.
Counter?
Yes, my lord.
Oh.
On 19/12/2007.
You can frame the question then?
Yes, your lordship.
All right. You say admit. The following questions are framed for consideration. Whether the appellant will be made liable to pay service tax You've not formulated questions, sir. Have you formulated any questions?
Question of law is in the appeal memorandum, my lord.
Goods Transport Agency
At
Service,
page-
bracket GTA service, for the period 16 November 1997 to 1st June 1998. In terms of the instruction dated 6 February 1998 of the Central Board of Excise and Customs, right? That instruction is by the CBEC, 6/2/1998. It is issued by the CBEC.
The Minister of Finance, page 19.
Ministry of Finance.
By the Ministry of Finance, Government of India, question mark. Is the appellant liable? No, is considering that the appellant is registered as a small scale industry, is it still liable? To pay service tax? As demanded by the impugned orders? Question mark. Is there any other question? Only small scale industry, and the first one is this retrospective.
Yes, sir.
The next question, my lord. Can I compliment?
Where have you raised it, sir? Where have you raised the question?
No, question is at paragraph 2 of the appeal memorandum at page 4.
I have framed a question on this. We've just dictated a question on this, sir. We have framed two questions.
My lord.
One concerns the retrospectivity. The second concerns your status as a small scale industry. Is there any other question?
Yes, my lord.
Which is that question?
Meanwhile, the Government of India amended by the Finance Act 2003.
Where have you raised this, what you're now telling us, this amendment 2003? Where have you raised it in your appeal?
I have not raised that issue.
You file an application, raise it, sir. That's the correct way to do things.
I will amend
size appeal. That whatever you have to do, you do. You say list for final hearing on 20th April 2023.
Item number 50.
Yeah.
Item number 50, I'm sorry to say that my file is not readily traceable. I wanted just to adjournment, my lord. Sorry,
at the request of, I don't object. No, but this is the department's appeal.
My lord.
My lord.
The same prayer, my lord, recently transferred. I'm sorry.
First put Mr. Panda's name. That's the most important thing, sir.
I'm sorry.
IA number, whatever for early hearing, this application become infructuous, it's disposed of. We just admit it, sir. Seems to readings are complete.
Yes, my it is admitted, my lord. Counter is also submitted, my lord. Counter and region counter submitted.
The same date, 28th April, will be fine because all the same matter almost. May I suggest?
So this is only a remand to the superintendent. What is there in this matter, sir?
My lord, as far as I recall is that the matter.
No, 1 minute. There's only a remand to a superintendent. What is wrong with this order? perusal of the impugned order reveals that all that the Stat has done is to remand the matter to the Superintendent of Excise for observing the principles of natural justice and passing a fresh order in accordance with law. The court does not consider this to be giving rise to any substantial question of law, which requires interference. The appeal is dismissed.
Item number 51.
Obligation.
Number.
Yes.
Item 51 relates to that interchangeability of liquor
Infructuous.
of the excise year 2017-18. It has become infructuous.
All right. Counsel petitioner,
Item-
the petition has become infructuous. Is disposed of as such.
Item number 81, 82, 83, same.
81 to 83 was the same. All right.
Item number 52.
Item 52, notices were issued and stay was granted. During the pendency of the writ petition, developments have taken place. We have given it in the form of a memo.
My lord, earlier, I am appearing for the State Pollution Control Board, my lord. Earlier, the so-called notice was issued for revoking the consent, keeping in view the direction of the Honorable Apex Court to make the effluent treatment plant fully functional, my lord. Now they have complied and we have given the inward.
A
We have
memo has
reviewed
been
the
placed in record stating that the petitioner has now been issued a consent order by the State Pollution Control Board, which is valid till 31st March 2024. Full stop. In that view of the matter, no further directions are called for in the present writ petition. Liberty is granted to the petitioner to approach the court in future if any cause of actions arises.
In the second matter, the date would just be 31/3/25.
Or
there are two
same order except the date is 31/3/25. All right.
We are all great.
All right.
Item number 53.
My lord, in item 53, the counter has not been filed. IDCO has to file the counter. My lord.
Last opportunity to IDCO to file its reply within 8 weeks, rejoined for the next date. List on 19th April.
Obliged, your lord.
Item number 54.
May I please? No instruction. No instructions dismissed.
Item number 55.
55 affidavit, I was supposed to file. I have already filed the affidavit in email mode. This is the copy.
No. Where are the instructions for timely disposal of all these applications? Where are those instructions? The affidavit is completely silent on that, sir.
Let me kindly give me.
What is the corrective steps to ensure prompt disposal? We have clearly said of stipend amounts.
This is only regarding payments.
No,
The,
you do one thing. In this year 2022, received applications from various students.
Yes.
You give us details of when the application was received, when did you disburse the amount?
Obliged. Lordship directed.
Although a counter affidavit has been filed on 21st November 2022, stating that the benefits in respect of the deceased Ms. Banita Nayak has been released to the family. The issue raised by this court in its order dated 27 September 2022 regarding open quotation, corrective steps taken to ensure prompt disbursal of stipend amounts to the students belonging to the SC and ST throughout the state, unquote, has not been addressed. Paragraph. The court directs the state government to file an affidavit placing in record details of how many applications for grant of stipend amounts to students belonging to the SC and ST were received in 2022 throughout the state, within what period were those applications processed and orders passed, and in how many cases the stipend amounts were actually disbursed and when. Full stop. Paragraph. The court would also like to the court will also like the state government to place in record the precise instructions issued on how quickly these applications have to be processed, decided, and benefits actually disbursed, including the modalities for such disposal. The affidavit will be filed at least 1 week prior to the next date. List on 21st February. Sorry, 23rd February.
23rd February.
February. Item number 56.
Seal cover.
This case, Lordship may kindly see in the last order that the affidavit in response to a particular order should be filed by today, otherwise there is a personal appearance. The mistake is on my part because in the last date I could not submit before your Lordship that affidavit is already filed since long and it is on record. Your Lordship may kindly see that affidavit is very much there, which was filed. Affidavit in compliance of the order dated 6/12/2021 by Surendra Kumar, Secretary General Administration. That is in May 2023. The date.
Which flag is that, sir?
Flag white.
Hmm.
May 2020. Yes, flag white. The hard copy is with me. It is e-filed on 18th May.
405 files of pending inquiry.
I don't may take this affidavit on record and your Lordship may fix it to some other date. In this case,
the affidavit dated May 2022 has been produced.
This is in compliance of the order dated 6th December 2021.
Interior is stated that the Superintendent of Police Vigilance Cell Cuttack had on 11th May 2022 submitted an action taken report on implementation of the task force report. Full stop. A total of 667 number of files relating to multiple allotments were obtained for inquiry. Full stop. It is stated that out of 162 files, 79 cases have been registered, 104 files have been returned after inquiry, and 401 files are pending inquiry. Full stop. Paragraph. There is no timeline indicated in the affidavit as regards completion of such pending inquiries. Full stop. A further affidavit we filed giving the updated status. Full stop. You see before the next date or further. List on 5th April.
5th April.
5th April.
My lord, in the last order, the lordship has directed that if the affidavit is not
You
filed,
say since
that
the
order may be modified.
all right. You say the presence of the principal secretary is dispensed with right in the beginning. You said all right.
Item number 57.
I beg your pardon, my lord. On 13 July, my lord has directed to production of the record. Last chance may be given to.
So there is no need at all to produce any record. Your lordship have only directed, I have copy of the order, to examine whether the Grihastha Udyog judgment your lordship have delivered is at all applicable to this case. That's all.
7 days.
And both the issues, let me say, there are two short questions are involved. Both the questions are limitation and both questions are directly covered by lordship judgment.
All right.
But one, your lordship can remember at page 17, page 16. There are two questions are there. My lords will find the questions and the answer is, judgment. My lordship can remember, first question is that without obtaining prior permission of the commissioner, whether 9(6)(c) provision that mandates before 6 months, he has to obtain, if there exceed 6 months, he has to obtain permission from the commissioner.
That's now settled.
That your lordship have already settled, perhaps. That is in Cobra.
Correct.
What is that?
Installations.
I'm giving the installation. That is one. And the and the next question is whether submission of audit visit report beyond 7 days time. Your lordship has dealt in Pal Constructions case. That was followed in Grihastha Udyog's case. Directly covered those two. Right. I'm giving
without verification of the record, my verification of 7 days is.
That's over. So how long you can keep adjourning? But I think last time we doubted whether you'll have the record at all. You may not even have the record.
Last occasion, your lordship was directed to produce the record.
You will not get that record. So it's a very old record, I think.
Twice they have taken time on this.
You see,
we have issued the letter on 20. Your lordship, only one occasion last time.
No. You see, 2 adjournments have already been granted for production of original records. Full stop. It is not considered reasonable to accede to a further request for adjournment, and that's code. Paragraph. There are 2 questions that have been urged by the SSC in the present revision petition. Read as under. Take from page 16, both the questions. Paragraph. As far as question 1 is concerned, it's covered in favor of the SSC and against the department by the judgment dated 29 July 2021 of this court in Writ Petition Civil 15956 of 2013, bracket Messrs. Cobra Vice Servicios SA versus Commission of Sales Tax. Paragraph. As far as question number 2 is concerned, is covered by the order dated 18th April 2022. In writ petition civil 16957 of 2009, bracket Messrs. Pal Construction versus the Assessing Authority.
And Gresti Udyog, Lords. That was followed by your Lordship, Gresti Udyog.
Followed in, just give us that decision.
9.
That one.
Gresti Udyog.
And the order dated 28 June 2022, in writ petition civil 9856 of 2010, bracket Messrs. Grihasti Udyog versus Commission of Sales Tax. Okay. That is the matter, the impugned orders of the tribunal and the corresponding orders of the ACST and Assessing Authority are hereby set aside. The revision petition is allowed in the above terms. No order system.
Deeply guys.
Okay.
Versus said in notings with counter by opposite party, copy not solved. Counter has not been solved on me.
It should be in course of day and something.
Counter affidavit be served on counsel to petitioner within
I may be allowed to file rejoinder.
3 days. Rejoinder to be filed for the next date.
Obliged. Interim order to continue, my lord.
Order to continue. List on 6th April.
Interim order to continue, my lord.
Said that's it.
Obliged.
Item number 59.
But here, matter that reassessment proceeding has been initiated under the behest of the additional commissioner and on the change of opinion. That kindly have a glance to the annexure 2, that is page 25. They have issued the notice under section 43. In response to that, I sought for the reason and they supplied the order sheet that is at page 33, annexure 6. My lord, kindly have a glance. That second para received the confidential letter number so and so dated from Special Commissioner headquarters along with the agreement copies between Sesagoa Limited and KP Enterprises. And this matter has been already dealt in the audit report and also 42 assessment. So I'm listing that assessment order.
Lordship, this is order of assessment and appeal is there, your Lordship.
Sorry?
No, here assessment is not challenged, notice has been challenged.
Your Lordship, let him appear.
No, I have appeared and they have given the reply. For that I have challenged. At page 31, and that is 42 assessment. That is 32, the dealer through a mining owner is not doing any sort of mining, raising or its own. Therefore, no material and manpower is used by it. Hence, there is no purchase made by the dealer. The dealer has entered into an agreement with Sesagoa Limited for execution of the ROM and purchase of same. By the latter, it allowed Mr. Sesagoa to a crusher at its mine and cross the ROM. So, purchase or payment of VAT.
Why should we interfere at the notice, show cause notice stage?
My lord?
Why should we interfere at this stage, sir, when only notice has been issued?
Here, another thing I have, after my preliminary objection, that in the that order sheet, my lord can find, they are proceeding at under section 101A. They have mentioned, and that 101A is not delegated to the deputy commissioner. That after my objection, the commissioner issued the notification that kind have annexure 1. That I have also challenged. He has no power at that time. On that annexure 1, page 23.
Till now, no order has been passed because of an interim order passed by us. No adjudication.
No, there are a lot of multiple issues like that because
all this you can raise, sir.
No, it is purely
reply, they will adjudicate.
It is purely change of opinion. My lord, order.
It's too early. No order has been passed. If the reassessment order has been passed, you can argue all that. It's only a show cause notice.
Where's
change of right now? Where is the question of adjudicating that, sir?
Apart from that,
the assessment order 42 is passed by the Joint Commissioner. And now Deputy Commissioner lower to him, he is reviewing the order.
Not reviewing. Only
Yes.
notice is issued, sir.
But he has issued the notice for assessing me.
Sir, can you not reply to the notice saying, sir, you do not have an authority?
Yeah, I have raised that objection, and from that objection, I came to know this.
Came to know what?
That he's going to assess me.
Going
Yeah,
to only,
yes.
sir. So you can raise all these points. All right. You see, the challenge in the present petition is to a notice dated 20th November 2015, issued by the
20th 11/2014.
20th November 2014. That's what I said.
Yeah.
Issued by the Deputy Commissioner of Sales Tax, Barville Circle, proposing to reassess the petitioner for the tax period 1st April 2008 to 31st March 2010. Stop. The petitioner appears to have filed his written objection thereto on 27 January 2015. So at a stage when no order was passed, the present petition was filed in which an interim order was passed by this court on 2nd March 2015. Paragraph. Considering that no final order of reassessment is yet to be passed, the court does not consider it appropriate to interfere at this stage. Court permits the petitioner to raise all pleas urged in the present petition in the proceedings by filing a further supplementary reply, if any, to the show cause notice, not later than 15 January 2023. 2023. Full stop. Full stop. The assessing authority will thereafter proceed to hear the petitioner and pass an appropriate order in accordance with law within a period of 2 months thereafter, and not later than 1st March 2023.
My lord, he may deal my preliminary objection there.
1st April 2023. Sorry.
Not to pass the assessment, he deal the preliminary objection.
Yeah, he'll do all that, sir. Yeah. The court clarifies it is not expressed in human merits. The petitioner is disposed of the above.
Item number 60.
Lordship, item number 60 and 61 praying for adjournment for 1 week, Lordship. Lordship, petitioner counsel daughter marriage is on 20th, Lordship.
All right. Counsel, petitioner is still in some personal difficulty. This on 24th April.
Lordship.
60 and 61. Item number 62.
Your Lordship may kindly turn to order dated 23/7/2015 notes. Here, my lords, what has happened? That TDS was deducted, my lord, by the newly added opposite party. 5 lakhs or more. Out of 5 lakhs or more, my lord, 3 lakhs or more posited. And there was a mismatch for 2 lakhs or more, my lords. Now, the CPP, my lord, without proceeding with against the deductor, my lord, they have now raised a demand against me, and they've already realized, my lord, 23,400 rupees. The man is now 70 years old, my lords. If your lordship would kindly turn to order dated 23/7/2015, where in the last penultimate paragraph, my lords, your lordship have said that learned counsel for the income tax department is directed to file affidavit as to what steps have been initiated against the employer for non-depositing the tax collected and deducted at source from the salary of the petitioner, my lords.
What have you done, sir? No affidavit filed.
I have not received any instructions. They have not copied. In first case,
Mr. Acharya was a relevant point of time, lords. Now the briefs have been transferred, and my learned friend was
not been transferred.
Another set of the petition was served on Mr. Chimanka.
I have already served it.
All right. Mr. Chimanka prays for one last opportunity to comply with the order dated 23rd July 2015.
But I've praying for some interim order, my lords. They have already started realizing it. There's a miscase, my lords.
All right, in that miscase 4289 of 2017, see till the next date hearing, no coercive steps shall be taken against the petitioner. In that main case, you see Mr. Chimakar states that after will be positively be filed 1 week prior to the next date. List on. Seventeenth April.
Item number 63.
64. 64.
63, sir.
63.
May it please your lordship, item 63, the penalty has been imposed at rupees 25,000 by Puri Circle.
Significant amount, sir. 25,000. Since the amount involved is
Well, because penalty, penalty matter.
Penalty, whatever, it's only 25,000. Since the amount involved is insignificant, leaving the question of law, but the court declines to interfere. The writ petition is dismissed.
Item number 64.
Copy जैसा फाइल ओरिजिनल ऑर्डर से कॉपी में फाइल भी रिटर्न
63, we're just not interfering, that's all, sir. All right.
Item 64.
Here, my lord, the petitioner is a manufacturer of pre-stressed concrete poles, my lords, and the poles, my lord, were given for the rural electrification under the Rajiv Gandhi Gramin Vidyut Kar Yojana, my lords. And if your lordship would kindly turn to Annex 1 at page 18.
No, this assessment order is challengeable in appeal.
So what has happened, my lord, is a 42 assessment after the audit report was done, my lords. My appeal, I filed an appeal against that, my lords, saying that the entire transaction is exempted as per Annex 1, my lord, of the government. There's a notification under 17A of the OVAT Act. Then, my lords, another audit report is submitted, and a 43 assessment is initiated against me. In the 43 assessment, they say, my lords, that since the entire transaction, my lord, is, if your lordship would kindly turn to that 43 assessment at page, my lords, 19. My lord, they drop the proceeding on the ground, if your lordship would kindly turn to page 20, my lords. May I just place it's a small paragraph, my lords. This is an order, page 20, your lordship got it?
Yes.
This is an order of assessment passed under section 43 of the OVAT Act on escape turnover in response to the audit objection by the AG Orissa in case of Mrs. So-and-so having his place of business at so-and-so, bearing TIN number so-and-so for the period 2/3/2009 to 36/2010. The dealer in the instant case is a manufacturer and seller of PSC poles. Scrutiny of assessment records revealed that the instant dealer has sold PSC poles, finished goods, to the tune of rupees so-and-so during the period under assessment to Messrs. Jyoti Structures, Messrs. Icom Tele, and Tata Projects Limited. The rate of sales tax of PSC poles during the period of assessment under the OVAT Act is 12.5%. However, the dealer has claimed full exemption as per the Finance Department notification number so-and-so dated 23/12/2008 by citing the reason that PSC poles are exclusively utilized in rural electrification under the scheme RGGVY in the state of Odisha. After receiving the AG audit objection, the dealer was given notice under VAT 307 for assessment of tax on escape turnover under section 43 of the OVAT Act. The dealer and the authorized learned advocate appeared, produced the books of accounts for verification and furnished the relevant certificates in support of his claim of exemption under OVAT Act, and the statement of the dealer was recorded in solemn affidavit. The dealer, the audit had raised certain objections, my lord. Then your lordship may turn over the page, my lords. After that, my lord, the last paragraph, my lord. The dealer did not sell these goods directly to the executants, but sold it to the contractors, who in turn sold it to the executants PGCIL. Hence, it is assumed that all these goods of value of so and so were sold exclusively for the purpose of rural electrification under the RGGVY. Hence, the dealer is entitled to get exemption of tax under the OVAT Act on the whole amount of turnover of rupees so and so of goods sold during the period under assessment. However, the dealer could not produce a certified copy of the works order given by the executant PGCIL to the contractors, that is Jyoti Structures, ICOM, Tele, and Tata Projects Limited for execution of work under the RGGVY, for which the dealer explained that these are exclusively private documents and not for use by any other agency. However, on the basis of the detailed sales statements with invoice number and corresponding amount of sale value of PSC poles, which are certified by the contractors and the executant, that is PGCIL, and as per the declaration of the dealer that these PSC poles supplied during the period of assessment is tailor-made and is exclusively designed and meant for the rural electrification project under the RGGVY, and it could be ascertained that the PSC poles of value so and so sold during the period to the aforementioned contractors is used for the purpose of rural electrification under RGGVY, hence eligible to get exemption under the OVAT Act as per the Finance Department notification number so and so dated 23/12/2008. Therefore, the dealer is assessed to nil under the OVAT Act. This was passed on 31st of July 2013. Then my pending appeal is decided, and that is Annex 3 on 19/8/2014. He remits back the matter to the original authority, that's the assessing authority, for verification of the certificates. Then, those certificates were there before the audit, during the audit. He observes, if your lordship would kindly turn, there's a set aside order, internal page 30, running page 30. Lordship may kindly turn to page 27, running page 27 of the set aside assessment order, the second paragraph. Lordship got it?
Yes, the dealer in
the instant case is engaged in the manufacturing and sale of PSC poles to the contractors. Your Lordship kindly mark these names. They were the contractors also in the 43 assessments. Messrs. Jyoti Structures Limited, Balasur, Messrs. ICOM Tele Limited in Mayurbhanj, and Tata Projects Limited, Balangir, inside the state of Orissa, and also effected interstate sale. The rate of tax, your Lordship may skip that part. Then your Lordship may come to page 30, this conclusion, penultimate paragraph, at page 30. In my observation, you got it?
Yes.
In my observation, had the dealer submitted original certificates, there was no need to submit Xerox copies. Further, the STO head of the audit team has not clarified if the dealer has submitted any original certificate, rather reported that the dealer has due certificates for the amount of rupees so and so out of the total amount of sale of rupees so and so during the period of under audit. Then, doing that, he raises a demand, against me of 61,70,528. The entire transaction is exempt. The 43 assessment by the self-same assessing authority, they consider these sales to these three contractors who were authorized by the PGCI to execute these rural electrification programs. Still, these demands have been raised against me.
Again, same procedure.
I was only humbly praying, subject to your Lordship's kind consideration. Your Lordships may remit back the matter to the assessing authority. I'll produce again all the certificates from the contractors. Let him consider, because at the end transaction, it has been recognized by them. Your Lordship would appreciate.
The appellate authority.
Again, again, there'll be a payment of tax when there's the entire transaction is.
That is
this Power Grid Corporation.
Is to avoid deposit. That's all. Long and short is that.
I'll again approach the Power Grid.
Alternate to.
Otherwise, the entire, my lord, it will keep on going like this. Only, my lord, your lordship may fix the timelines, my lord.
All right.
Because PGCIL, my lord, PGCIL, I'll approach PGCIL. They have given me some certificates. Let me produce it before the assessing appeal.
Not assessing, sir.
My lord, if, my lord, may I just
yes,
make a last-ditch effort, my lord. If I am unable to produce the certificates, my lord, his order stands, my lord, I'll go up in appeal.
No.
So give me a chance, your lordship. No. But otherwise, your lordship would see, my lords, that this 61,000 lakhs some odd, which is now demanded, my lord, is to completely, my lords, exempted transaction, my lords, for the rural electrification. My lords.
Before the appellate authority produce it, sir. All right.
As your lordship, please.
The council, the challenge present petition is to an assessment order dated 29 September 2016, passed by the sales tax officer, Baleshwar Circle, which is an appealable order. Consequently, while permitting the petitioner to avail of the appellate remedy, the court declines to interfere at this stage. If the appeal is filed not later than 1st February 2023, accompanied by an application of continuation delay, explaining the delay on account of the pendency of the present petition, considered in accordance with law by the appellate court clarifies it is not expressed anywhere in the matter. The originals be returned, subject to being substituted by attested photocopies thereof. All right.
It's a complete exempted transaction.
All right.
Obligement.
All right.
Item number 66.
Withdraw.
66.
Sixty-six.
66.
You have to file a admiralty proceedings, no, for these things. How do you come in a writ petition? In fact, in this court also admiralty suits are being filed. This is the same ship being detained and all that.
Order has been passed and yet bank guarantee has been released, amount has been given.
Given already.
Yes.
All right. So it's infructuous now.
No, date short, my lord. Date short.
What is he saying? What are you saying?
So this is a case of export.
No, 1 minute. You were saying something, Mr. Chimanka.
Yes. No, we have passed the order. Provisional assessment has been made and the bank guarantee of 30%, 5% has been released. Order has been passed as per the rejoinder. Page number 42.
But my lord, my prayer is not restricted only to the finalization of provisional assessment.
Rejoinder, page 42.
The ship carrying my goods was illegally and arbitrarily detained for 9 days. And for that, I have incurred a cost of more than 1 crore of rupees.
That you have to file in a suit, sir.
My lord, I will only refer to
a writ petition.
My lord, I will refer to your lordship's order.
Yeah, the realities.
In Worldline Tradex Private Limited case, my lord, wherein your lordship has held that compensatory can be entertained by writ court. It is available at page 146, running page 146 of the appeal memorandum. My rejoinder is page 153, running page 146.
Yeah, there's a whole line of decisions, sir. There's nothing we cannot do under 226. There will be a decision for everything that we can do under 226.
Lordship. May I rely on another decision of the Supreme Court, my lord?
Yes.
On the same issue?
Yes.
Kindly refer to paragraph 9 to 11 of this order in the case of Rudul Saha, my lord, which was passed way back.
Please, what is the context? What is
the context is, my lord, that
Rudul Saha's context, the context of your case is the same, sir.
Absolutely, my lord.
I see.
Total abuse of power by the authorities.
My goodness. All right. All right. It's an education for us, sir. It's all right. You can argue. See, the privilege of argument is yours. The duty to hear is ours.
Lordship, I will only point out.
We'll acknowledge that.
I will only point out, my lord. I will only point out one thing only I will point out. In the detention order, they mentioned that your
English language is a wonderful language, sir.
No,
I'm just, even that you're objecting? No.
No.
So I'm just making a comment.
I will only make one sentence, one submission.
You're not even letting me make a comment, sir.
Please.
I think you're in a hurry.
Sorry.
You're in a hurry, sir?
No, not at all.
You're in a mood to listen to something light? No. No, you're clearly not in the mood. It's all right. Now you carry on with your
my only submission, my lord, kindly refer to the detention order. Kindly refer to the detention order available at page 68, my lord.
All right.
Page 68, in the very first paragraph, the appropriate authority held that the cargo was declared to be having Fe content below 58%, whereas by way of testing the same, it has been found to be having Fe content of more than 58%, above 58%. That's the ground on which they detained my ship for 9 days. But in the course of the pendency of the writ petition, the appropriate authority finalized the provisional assessment. In the rejoinder filed by the department, in the counter affidavit filed by the department, they have said that not less than 7 to 8 times that we have the test report and it is saying more than above 58% Fe content. But while finalizing the provisional assessment, he doesn't whisper about having any report with him which says that the Fe content was more than 58%. So this is the extent of abuse of power by the authorities concerned in order to put me in a loss of more than 1 crore of rupees, my lord. I only pray that this should be receives a favorable consideration by your lordships.
All right. We see the challenge in the present petition, which was filed on 22nd December 2020. No, you see the present petition was filed on 22nd December 2020 for a direction to the customs authorities. Seeking the quashing of an order dated 18 December 2020. Passed by the Inspector Gopalpur Customs Division. Detaining the vessel MBA Liberty under Section 110 of the Customs Act 1962. On the ground that the cargo it contained had E content of below 58%, whereas upon testing it was found to have E content of above 58%. On 24th paragraph, on 24th December 2020. An order was passed to the interim order was passed to this court, noting that the petitioners had deposited bank guarantee bracket BG to an aggregate extent of 35%. And on that basis, a direction was issued for release of the vessel with an undertaking that in the event any customs duty is leviable after final assessment by following due procedure of law, the same shall be recovered from the petitioners after adjusting the amount already deposited by way of bank guarantee. Paragraph. It appears that pursuant to the above order, the vessel in question sailed out on 25th December 2020 after being detained for a period of 9 days. Full stop. Paragraph. On 24th June 2021, the Assistant Commissioner, Gopalpur Customs Division, finalized the provisional assessment of the relevant shipping bill at single courts in duty. Unquote. Full stop. Paragraph. Counsel the petitioner now raised that directions should be issued to the opposite parties to pay compensation to the petitioner for wrongful detention of the vessel for 9 days. And in support of such submission, reliance is placed on the decision in Rudul Service, State of Bihar, 1983, 4 SCC 141. And to urge court to entertain the writ petition, continue to entertain the writ petition. Reliance is placed on the decision World Line Tradex Private Limited versus Commissioner of Customs bracket import 2016 340 ELT 174 bracket Del. Paragraph. As regards the aforementioned, the court is of the view that it would involve disputed questions of fact regarding the justification for detention of the vessel by the authorities in the first instance. Stop. This is in particular, this is on account of the fact that the petitioner has throughout been maintaining that there was no basis for the conclusion of the authorities that the FE content of the goods was not in accordance with the declaration made by the petitioner, and that the finalized assessment order and that the provisional assessment of 24 June 2021 made no reference to any test report on the basis of which the detention order was issued. Full stop. These matters can be best tested in civil proceedings where evidence would have to be led by both parties. Consequently, leaving it open to the petitioner to seek appropriate remedies in accordance with law, with any other grievance the petitioner may have. This is disposed. All right.
Item 67.
I think it's the rise. The petitioner stated in some personal difficulty today. Interim orders to continue. There is interim order?
Interim order.
Interim order to continue. List on 6th April.
Item number 68.
Madam, one approval wanted to file the rejoinder matter in this case. They already filed counter. They filed the rejoinder. Issue involving this case that they have adjusted my refund amount at page
33 annexure 2, I claim refund 2,95,440.
All right. Rejoined to be filed before the next date.
Lordship, in these cases, we not here challenge the intimation. And the issue involved is without non-consideration of the not paid the amount in due time EPF and ESI. Then the judgment will not changed by the Supreme Court. Not checkment private number CIT. If it is not paid in the due date, it cannot be claimed deduction under the Income Tax Act. So now earlier that judgment was that it should be, if it's filed before the return, it should be accepted. Your Lordship, you also the same. But that is change in the checkment private limited by CIT reported in 448 ITR. So that is the only grievance and challenge the intimation. And it's the appeal is there. If you want to file a result, I don't have an objection.
They adjust some entries in whatever mentioned in my returns without giving so much notice to me. Where is the provision to so much adjust whatever the department likes?
No, what
so
is
it is. Suppose it is a question. It is a debatable question.
For judgments, you examine the judgment.
I have no that judgment because my brother said that.
What is give us a citation?
Checkment Service Private Limited was a CIT1 reported in 448 ITR. Recently, Lord.
Mr. T.K. Satpathy, learned standing counsel for the department, states that the decision of the Supreme Court of India.
Yes, Lord.
In
Lord, ITR.
No.
Checkmate Service Private Limited. Checkmate
Services Private Limited versus
CIT1.
CIT bracket 1. 448
ITR. Page 1 or 2 no time.
Page 1. And submits that and submits that in view of the said decision. The remedy for the present petitioner would be to file an appeal.
No, it is not. It is on the issue of not the claim of payment of the statutory deposit not paid within time may not be allowed as deduction. Earlier, if it was filed before filing of return,
or
then
stating holds that
I have averred that basing another decision at my paragraph 4 of my writ petition. They have answered no in their rejoinder. They remains. They did not show anything. They remain silent.
That's an earlier judgment, sir. This is a later judgment.
Enclosed before my lords.
And states that.
So let me give some time to file a rejoinder. Everything to clarify, my lord. There is no still nothing. What is problem to the department?
It supports the case of the department in the present case. Then you say counsel for the petitioner needs time to examine the said judgment and also file a rejoinder. List on 6th April.
Item number 69.
May it please your lordship. Your lordship may kindly see order dated 23 August 2022, where the department had agreed to my prayer, which was to provide the copy of the video conferencing proceeding held with the National Faceless Assessment Center. But they have till date not provided it.
Well, today I received it. And I will send the mail to
Mr. Shibanka said that he'll be sending the link, video conferencing link to the petition, counsel the petitioner today itself.
I have sent the court also. Mail, Rasti.
Anything else? Is that will that?
No, your lordship, only this much.
That view where no further directions are called for. The petition is dismissed. All right.
Obliged.
Item number 70.
70 and 71 may be after lunch.
All right.
Item 72.
72, my lord, there's a noting that opposite party number 6, the AD has been returned unserved. And OP number 9, my lord, it appears that some illegible.
No, I have appeared for OP number 9 on Monday.
No, I'm talking about OP 8.
Yeah.
OP 6 and 8, my lord, I may be allowed to take fresh notice against 6 and 8.
All right. Fresh notice to opposite parties 6 and 8 returnable. April.
Sorry,
5th April.
Interim order to continue.
Order. Up to the OP number 1.
Yes. Item number 73.
My lord, here I have challenged the jurisdictional issue, my lord. 148 initiation of 148 proceeding, my lord. The assessment here is 2016-17. And the notice 148, my lord. 30th June 2021, my lord. This is beyond 4 years, my lord. Even after 1/4/2021 provision applies, it is 3 years, my lord, since it is the amount is below 50 lakhs. So
Counter file.
Yeah, I have to verify it.
Or it's pointed out that the notice under section 148 of the Income Tax Act, but the order under 148(a)(d) is already in passed.
my lord, yes, my lord. And the next, my lord, page 11, para 4, my lord. The objection of the assessee is not acceptable at the assessment year 2016-17, which is proposed to be reopened falling within the 3 years base year of calculating the time limit being the assessment of 1920. Where is there provision to shift the assessment year from 16-17 to 1920, my lord? There is no such law in provisions under the Act, my lord.
No, the last but one paragraph is 16-17 only.
Lord,
Page 11 bottom.
But that is 16, my lord. 16 is the assessment year. That above paragraph bottom is changing the calculation, taking it as a 1920, my lord, assessment year. The time limit being assessment year 1920.
So, but after that, Punjab and Haryana, what we've held.
No, my that is here the jurisdictional issue, my lord, and as well as 151, the approval to be granted by CIT. Here
Said all issues.
My lord, here the jurisdictional issue, my lord.
You don't have the copy of the order of our. So you people are department people. If you don't keep a copy of our judgment, which helps you, what is there?
My lord, in that case, there is only your
last judgment.
148 capital A, sir. We heard the batch for so many days to pass the judgment. You don't have a copy.
My lord, in GK driver case, the Honorable Supreme Court held that.
Are you aware of the judgment we passed in all your petitions?
Yes, my lord, that order.
Where is that copy? You don't have that copy. You also don't have a copy. We heard the matter for some weeks on end and passed a whole judgment, and neither of you has a copy.
In those cases, there is no jurisdictional issue, my lord.
We have to do from our memory. You will pretend that we never passed any such order.
No, jurisdictional issue was not there, my lord. Only that our objection were not considered properly.
You
that
don't
was
have
the issue.
a copy of the order, sir, and you're arguing about that order. This is remarkable. How many petitions you had, Mr. Panda, in that batch?
Only 3, my lord.
Only 3? All right. So, because you have only 3, don't retain a copy of the order.
19172.
Remarkable.
It's
SSC council, nobody has a copy. Anyone watching these proceedings will think we've never dealt with this matter.
Actually, my presumption is that order is not applicable to in present case.
Best sir, don't produce, don't keep a copy. It's okay, sir. You don't have a copy of the order, but you are prepared to distinguish the order. And you are in a very good position, sir. Don't have anything, copy of anything. Leave it all to the court. If the court has a memory, it will recall. Otherwise, today, if we had allowed this petition, you would have said nothing. So this is unfortunate because it's all happening in your presence. All these endless number of orders that we are passing. You're putting so much burden on the court. Order copies also, we only have to pull out. Justice Raman is keeping a full bunch because he knows he can't depend on all of you. No, I'm saying. In view of the order passed by this court on 1/12/2022, in writ petition civil 9191 of 2022 and batch, bracket Kailash Kedia versus Nifkat officer, Ward 1. the court disposes of this writ petition in the same terms and vacates the interim order.
Item number 74.
Milord, 74, 75, while preparing notes yesterday, I found my friend has filed some counter affidavit in both the matters, copy not given to me. So I may require to file a result urge in both the matters, 74. Both are state excise matters, my lords. Let them give copy of the counters to me today. I'll file a result urge.
The copy, but
This is a license for the year 2014-15.
yes,
Is it still alive? What is the
that is what
period
I'm
of
saying,
license? What's the period of license normally, sir? Just come to page 18, the prayer clause.
this prayer.
Well, in fact, in that score, I'll be reading some instruction because in the meanwhile, the plant is closed and the license period has gone because of interim order. They had granted license for some time. Since the plant is closed, only issue will be remaining. And part of the prayer is become redundant. I'll take instruction on that. Also, we close it in lax. Wait. Also, can close it in lax date. Let us have some instruction on this so that part of the prayer is redundant. We will not waste time on that.
No, even today we should not waste time, sir. Why should waste today's time?
No, this
Waste today's time.
he suddenly got listed. I want some instruction.
Rise for lunch. You also have your lunch. Meanwhile, talk to your client. We'll come back. Everything will get resolved.
Let's give me some time. There are some counter affidavit. Let me have a look at that.
14-15, sir. License period is 14-15. Obviously, it's not set by. If your plant is closed, why keep the petition pending?
May I submit one?
There's some demand also involved in
That
these
is what
matters.
I'm saying. I'm saying in his favor, he's only obstructing. What my respectful submission, that one part of the case is redundant. There is no dispute. So far as demand is concerned, he has made a representation to this government, Honorable Secretary, and that is at page 59.
The time-bound consideration.
Yes, that he will consider, he will treat it as a division.
I will
consider it.
Or
If the favor is passed that you pay the demand dues, then he will come forward with a.
Admittedly, the prayers of the one portion of the prayers in the present writ petition concerning renewal of license for the year 2014-15 do not survive. Further, it is Mr. Pangari, senior counsel for the petitioner, informs the court that the petitioner's factory has itself closed down. Paragraph. As regards the representation made by the petitioner
On 16th April.
on 16th April 2015
Annexure 19.
to the Principal Secretary, Department of Excise, Odisha, a direction is issued to the said authority.
Secretary, you not may write a secretary.
Yeah, to the Secretary
Excise Department.
to dispose it of after hearing the petitioner within a period of 8 weeks from today.
My lord may say 3 months because
All right.
many
Within a period of 3 months from today.
Petitions for extension also.
All right. Within a period of 3 months, and in any event, not later than 15th March.
The interim order will continue. There is a stay order here.
Till such time, the interim order passed by the court on
28th August 2015.
28 August 2015 shall continue. The court clarifies it is not expressed any view in the matter.
75.
He shall hear me.
76, both.
After
74
hearing.
and 75.
Yeah, after hearing only, sir.
Minutes. Obliged.
All right.
Item number 76.
Item 6, may I please?
Yes.
On the last occasion, my lordship has said that a notice has been issued to the opposition of 5.6, my lordship, and she has filed the counter affidavit. I only prefer a rejoinder file, my lordship.
Who is this?
Your lordship, the application for illegal demand raised by the opposite parties pursuant to audit report to account general to
Audit
depot.
report demand your lordship is sending back to secretary that it will be treated as a notice that order copy.
Mr. Patra will have it.
Yes. The audit report order. We'll file, give a report, provide order.
So we'll pass it order after lunch. Just bring it by lunch.
Yes.
I'll file a rejoinder, my lord.
Not necessary, sir. It's an order, standard order that we are passing. Order, so. Pass over.
Item number 77.
None appears dismissed.
Item number 78.
My lord, in item number 78, the petitioner is dead and the matter has already become infructuous.
All right. Disposed of as infructuous. All right.
Item 79.
The memo is taken into record. No instructions dismissed.
Item number 80.
Liberty may be granted to file an appeal, my lord.
All right. Counsel petitioner seeks leave to withdraw the present petitions with liberty to file an appeal in accordance with law. If such appeal is filed not later than 1st February, accompanied by an application of contention of delay, citing the pendency of the petitions and the reason for the delay, shall be considered by the appellate authority in accordance with law. The court clarifies it has not expressed any view in the matter. The original annexures were returned, subject to being substituted attested photocopies.
Both the process. 81, 82, and
Already
84. Item number 84.
Mr. Rabu.
84. 84.
84, Lordship, the petitioner is challenging here the order with regard to shifting of the shop 32 kilometers away.
Just a minute.
Clear.
I am appearing for the OP number 5. I'm filing counter in today. I am serving the copy.
Lord, in that case, I'll humbly pray, since the license will be up to March, Lordship may kindly take up the matter sometime in January, Lord. Otherwise, again, I'll have to amend it again.
Mr. Patra, appearing for OP number 5, states that he'll be filing his reply during the course of the day. Rejoinder before the next date.
Copies are not.
List on 25th January.
25th January. Grateful.
Item number 85.
My lord, 85. My lord, Mr. Bose is not well, my lord. So that's why I was praying early morning for adjournment, because I've taken the consent of.
All right. Counsel for the petitioner is stated to be unwell. List on 5th April.
85, the second sub item, name is not reflecting for some reason. Kindly.
Your name is it?
My
name of Mr. Devashish Naik
Municipal Corporation.
For the CMC.
5th April.
We'll continue after lunch.
From the officer, your lordship.
My difficulty, I don't have any objection to my learned friend taking time. My difficulty, my lord, is that entire refund, my lord, which is now the lifeline of my industry, is stuck up.
No, we'll not give a long date.
Sometimes in January, at least first week, possible.
Yeah, at the request of Mr. Mishra, who seeks some time for instructions on amendments in the rejoinder, filed today. List on. I think 31st January is safe, sir. 31st January.
Your lordships have a heavy boot, my lord.
I know.
Because of my difficulty, I was just trying to oblige.
Item 71.
I'm sorry, it's the same matter.
Same.
For different period.
Correct.
Thank you.
Item number 76.
76, may please.
Same order, sir.
Said that is the same order, but
whatever changes you want to tell us, demand notice date to change.
Demand notice change date has been told, because I am challenging that demand notice.
That's what? No, date of your demand notice. Which is the date of your demand notice?
Demand notice date is 18/3/2015.
18 March 2015.
15.
In one matter, in the next matter?
Next is 23/3/2015.
The next matter. All right. And then you can say not later than 31st January. No, you can say actually not later than 28th February 2023. Pass a reasoned order not later than 28th February 2023 shall be communicated. The petition not later than 7th March. All right. All right.
Obliged.
Weekly list for hearing. Item number 7.
Mr. Mahapatra, Mr. Mahapatra, sir, it's illness.
Illness. All right. We'll stay on board. All right.
Item number 9.
Let's say 9 may stay on board next week.
All right.
Your Lordships, I'm appearing for the respondent. Because I have some personal difficulty next week. If it can be kept in January instead of.
It will come in January only, sir. Virtually, it will come that. All right.
Item number 12. 12 and 13.
12 and 13. All right. All right. I think the better thing is to ask who is ready in which matter. That's better.
Item 29 also next week.
No. Whoever is ready in whichever matter, we'll take it up.
Item 22, my lord.
Mr.
Roy, item 26. Mr. Roy, and item 26, my lord.
Okay. All right. You argue, na?
Item 21.
22, my sorry.
22. Whatever. Wherever you're ready. New Khadi Niketan.
Sorry, yes, sir. My lord. My lord, the action of law has been framed at 26 your lordship. By order dated 3rd of May.
Sari, Pata, Dhoti and Gamcha. They fall under entry 3 of part 2 OET.
Part 2 of OET scheduled and accordingly, your lordship. My lordship, although the second question has not been formed in page 26, your lordship, and let me read out the second question, lordship. Whether in the fact and circumstance case, the division bench on Orissa sales tax time was right in law to enlarge the meaning of textile at entry serial number 3 of part 2 of the schedule.
Same thing, sir.
To include sari, pata, dhoti, gamcha and all varieties. When the use word including at the same entry intends to mean a specific product, that is cotton fabrics and ready-made garments. Let's say, lordship, I will take to only 3 entry serial number of part 2, your lordships. Entry serial number 3, my lord.
Yes.
Part
textile
2.
Products. Yeah.
My
It starts with the word textile products.
My lord. Entry serial number 3 says, my lord, textile products, including cotton fabrics and ready-made garments.
Right.
Lordship, kindly glance to just previous entry, your lordships.
Right.
Electrical goods, including motor, material for transmission tower, and conductor, cables for manufacturing.
Right.
Lordship, kindly glance to entry serial number 5 of part 1, your lordship.
Pure silk fabric.
In part 1, entry serial 5, pure silk fabrics, silk, artificial silk, silk yarn, raw made silk, your lordships. My submission is the lordships. In entry serial number 3, after the word textile product, including cotton fabrics and ready-made garments has a fine place, your lordships. So textiles of many variety, either it may be a cotton, it may be a rayon, it may be a silk, of any mixture of any of these lordships. So the word entry serial number 3, your lordships, intend to say that it is a word amounts to consisting of a confining to, and not a words of enlargement and extension, as generally used to mean, yes, lordships. Yes, lordship, before start my submission,
difficult.
let me place my reference.
Yes.
If the pilot is acceptable to my lord,
Correct.
Whatever
You have to try. Correct.
Yes, my lord. I oblige to pledge, my lord.
Right.
My lord, let me lead out to textile products, including cotton fabrics and ready-made garments. My submission is that, for a moment, your lordships, if the intention of the was to take into ambit entry serial number 3 or textile product, that is woolen, rayon, silk, cotton, or any mixture of that, then the entry including cotton fabric should not have been there, my lord. Because merely by textile product, it could have included all the entries, your lordships. And thus the previous entry says, because that is the intention, your lordship, entry serial number 5 of part 1 consisting of silk fabrics, your lordships. Had it with the intention to, within embargo of serial number 3, to incorporate all three, then there should not be separate entry at entry serial number 5, my lord. So,
no, but we are not concerned with entry serial number 5 at all. We're only picking it up as an example.
My lord.
So that in entry serial number 5,
entry serial number 5 is considered pure self fabric.
No, the word including itself is not there. So I'm saying let's not go there.
My lord, I am grateful. So the previous entry, let's say, my lord, it is electrical goods, including motor, material for transmission tower, conductor, oblique cables for manufacturing. My lord, here as entry serial number 2, the word including has been used as a word of enlargement and extension, your lordship.
Correct.
But at entry serial number 3, the word including has been used as a word of limitation, consisting of and confining of, your lordships.
Why? Why is the same word?
If the intention would have been to incorporate all the textile product, then cotton fabrics itself had not been found. By not mentioning the cotton fabrics also, it would have been covered under the textile.
Correct.
So the other than cotton fabrics,
this is only like the rule of abundant caution, more clarity.
But I think that let me fuse some of the reference of the case like comparison to this effective lordships. I have relied upon three judgments of the Honorable Supreme Court and one of the Assam Guwahati High Court, your lordships. Let me go to the fourth one, the Guwahati High Court, your lordships. That is page 21 to page 23, your lordships. Before inviting the set call, the issue with regard to entry tax, your lordships. The entry serial number 4 of the Guwahati Sales Tax Act contains sound page 24, your lordships. Last line. Last but 2 lines, sound transmitting equipment, including telephone, mobile phone, pagers, and components and parts thereof. So the issue before that, whether the optical fiber, even though it's a classifiable to be a sound transmitting equipment, whether to be covered under the entry serial number 4 of the Assam Entry Tax Act, your lordship. There itself, my lord has held that since in the entry serial number sound transmitting equipment, there is a word of including, and including followed by the other accessory, that is telephones, mobile phones, pagers, and components thereof. Then the optical fibers is not covered under entry serial number 4 of the Guwahati.
By this interpretation,
my lord,
the word including is being substituted by the word such as. Such as. Only then it will make sense. instead of the word including, suppose you rewrite saying such as transmitting equipment such as, suppose you put, will not the same answer come, sir? What the Guwahati High Court is saying,
my lord,
becomes even clearer if you substitute the word including,
my lord,
with the words such as.
my lord.
Question is, can we substitute like this? Legislative intent,
my lord,
is expressed in the words used.
Exactly, my lord.
So you have to have strict construction taxing statute.
My lord.
Can you rewrite? Can you substitute?
No, my lord. So
that's
let's
the
read
answer.
relevant para of the page, para 35, my lords.
Yes.
Page 33, your lordships.
Yes.
What emerges from the above discussion is that none of the authorities cited by the Mr. Dubey lays down the word includes or including occurring in the definition clause will always reflect to the slip intent to expand the meaning of the term sought to be defined. Hence, it is not necessary to that always and invariably the word include or including which appears in a statute would be aimed to at expanding the meaning of the term sought to be defined. By using the word including or including, where the words include or including brings within the slip or term such word or words which carry very wider meaning or which do not ordinarily fall within that term which is sought to be defined, then the term which is sought to be defined must be constituted and comprehending not only such things as they signify according to their nature or importance, but also those things which are interpretation clause declares that the said shall include. However, when the word include or including is used in interpretation clause for the purpose of including within its definition of the term a particular item which would otherwise also fall within such a term, such use of the word include or such inclusive definition of a given term would imply exhaustiveness and limitations. When this test is applied on the fact of the present case, it becomes transparent that by using the word including in entry 4, the legislative intent to illustrate as to what the item express sound transmitted equipment would convey. It further logically follows that the entry 4 sound transmitted equipment would include only telephone, mobile phones, pagers, and components part thereof, and no other items such as optical fiber, cables, and accessory. Such situated thus, it is clear that do not hold that no entry tax in terms of entry 4 of the Act 2000 can be imposed on the entry goods such as optical fibers, cable, and accessories, my lord. My lord. Apart from that, there are 3 other orders of the honorable judgments of the honorable appeals court. That is one of the Manalaki oil mills and state of Andhra Pradesh, followed by the south coasting, the roofing tiles, and also the NDP Nambuthikas. Without inviting straight to the orders, your lordship, let me give the brief facts of the case of the Mahalakshmi oil mills. My lord, in the above case was with regard to the levy of sales tax under the Andhra Pradesh General Sales Tax Act, your lordships. Section 8 of the Andhra Pradesh General Act, there is a provisions for exemption of goods falling under the 4th schedule of the Act, your lordship. Entry serial number 7 of the 4th schedule consisting of tobacco product, your lordships. But the definition of tobacco has not defined under the Andhra Pradesh Sales Tax Act, but has been borrowed from the Additional Duty of Excise Act 1957, your lordship. In the Additional Duty of Excise 1957, the tobacco has been defined, your lordships, as follows, your lordships. Page 5, my lord. Page 5, my lord. Tobacco might be able to find. Oblige, my lord. Tobacco means any form of tobacco, whether cured or uncured, whether manufactured or not, and includes the leaf, stalks, and stems of the tobacco plant, but does not include any part of tobacco plant while still attached to earth. The question is, your lordship, is that whether the seeds of tobacco is to be classified as a tobacco or not. That's the issue before the court, your lordships. And the Honorable Appeals Court has held that, your lordships. Para 11, page number 6, your lordship, of my compilation, your lordship. The immediate next page, your lordships. Para 11, your lordship, your lordship. We are inclined to accept the contents on behalf of the state that the definition under consideration which consists of 2 separate parts which specify that what the expression means and also includes its obvious meant to be exhaustive. As Lord Watson has observed in the Dealworth versus Commission of Stamps report so and so, the joint use of the words means and include can have the effect. He said a passage of quoted with approval to earlier decisions, Your Lordships. Then I followed the repeated portion, Your Lordship. From the fifth line, Your Lordship. The word includes is very general use in interpretation clause in other enlarge the meaning of the word or phrases occurring in the body of the statute, and when such a word is used or phrase is used must be construed and complained not only such things are slightly different. According to Your Lordship, in para 13, Your Lordship, which observed that, looking thereof, the term definition is more closely, it is quite clear that tobacco should do not fall in the second or inclusive part of the definition. This part of the definition is important. It specifically excludes from the definition any part of tobacco plant so long as it is still attached to earth. It makes mention only parts of the plant and severed from the earth. It is a common knowledge that when the plant is severed from the earth, its plant will be composed of not only leaves, stalks, and stem, but also seeds. Yet the inclusive part of the definition not only the leaves, stalks, and stem, derivative one should not think of avoiding mentionable. So in the above analogy, my lords, it is held that this tobacco is not qualified to tobacco, Your Lordships. And there are two other decisions, Your Lordships, with the my Lordship permit, I will go through, otherwise not.
Then we permit, I mean,
my Lord. The
pottery industry includes the following articles.
Yes, man. There are only 9 articles have been incorporated. The issue is over there whether Mangalore pattern roofing, whether it will fall under entry settlement 22 or not. And there itself also, my Lord held that the Mangalore roofing pattern shall not be incorporated thereof on entry settlement 2. Similarly, also case of last case, Your Lordship, in the case of NDP Namrudipa, Your Lordships, this is with regard to fixation of the pension of honorable judges of the Kerala High Court, Your Lordship, with regard to fixation of the emoluments, Your Lordships. And there itself that
now we are going far beyond taxing statute.
My whole of intention is to brought to my sorry, I have to convey before my Lord that this is the order of the Supreme Court. So basing on that, I shall not be wrote under entry serial number 3, which is of not of potency, Your Lordships.
Okay. We don't agree with you, sir.
Grateful, my Lord.
So we'll pass the judgment. We'll pass it.
I don't know. My Lord, item number 20. I'm sorry, item number 30, Your Lordship.
You'll do a detailed thing. That's why it's nice to read it.
My Lord, item 30. Sorry. My Lord, item 30, my Lord. Separate bench, please, my Lord. Separate bench, my Lord.
Oh, item 30.
My Lord.
Okay. Yes, before a bench, it doesn't run, not a
Oblige, my Lord.
In the regular, in the miscellaneous.
Item 21, man. Yeah, item 21, man. On 10th May 2018, this Honorable Court has already framed the question of law, man. Whether on the facts and in circumstances of the case, the London Sales Tax Tribunal is justified in set aside the order of the Joint Commission of a Commercial Tax in Annexure 2, thereby restoring the order of assessing officer in Annexure 1 and imposing the tax on goods or item which has not been included in serial number 20 of Part 2 of the Scheduled Goods of Entry Tax Act and law laid down by the Honorable Court holding that cashew nut does not come within the definition of fruits. So entry number 20, my lord, cashew nuts packaged packaged 2% rate of tax is there.
This dry fruits, jam, that one.
Yeah, yes, my lord.
Dry fruits, jam, potato chips, packaged cashew nuts, and pickles.
We are not packaged. Only cashew nuts.
You are cashew nut.
My lord.
Packaged cashew nut. Oh,
packaged name.
Oh, you are a loose
cashew nuts. That's why this court has framed the question of law. And the Lorient Appellate Authority has also at page 18 clearly stated, in view of the above definition of cashew fruit as revealed from the Wikipedia, I accept that cashew nut is not.
The contrary view has also been taken by the tribunal later on. You have that order.
Tribunal itself has later on taken a contrary view.
No, my lord, I am not.
That's what just Raman
Your
remembers.
Justice
Because that is coming under the dry fruit.
Justice Sasikant Mishra,
Your Lordship.
as he then was.
Your Lordship.
Chairman.
Subsequently, and
He
it
has-
is coming within the purview of dry fruits, Your Lordship.
No.
Case was your
No. Cashew nut, loose cashew nut is not within this entry. Only package.
What was the impression by the tribunal later on that it will not come within the fold of dry fruit because you have specifically carved out part packaged cashew nut only. Your intention is to tax only packaged cashew nut, even though it falls within the ambit of dry fruit.
Correct.
So dry fruit may be accrued and other things.
Correct.
But as so far as this is concerned, kernel is there, not there. So packaged cashew nut is only you are liable to tax under entry tax, not any other.
All right.
It is restrictive.
So this is answered in the negative. That is in favor of the SSC and against the department. So the revision petition is allowed. All right. We pass the detailed order.
Item 32, my lord. My lord, in that case, my lord, that my lord, my learned brother Prasanna Kumar Padi has not accepted the copies because he said that he is no more the advocate in this case.
Oh.
And Mr. Satwadi, he has also said that I am not an advocate in this case.
Then who's going to take?
Who has taken the copy? I don't know exactly. Who has to take the copy in this case?
To issue fresh notice.
Income tax. Nice. Central. Service.
Then who will accept notice?
I will accept it.
Or Mr. Chimanka now states that he will appear for the opposite parties. A complete set of papers be served on him.
Yeah.
All right. Let it stay on board.
Next week.
What,
Next month.
whatever it comes whenever. 33 now.
No, it will come in January, man. Next week, I am
Virtually, sir. Let's see. Next week we may not be able to take it up. Or only 1 week left. Or
33 next item. In next item, your lordships has while formulated the question of law, has held that here is the interesting question. Before my lords, the tribunal stated that as because the unit has not been, the trust has not been registered under the Income Tax Act. That's why they are not entitled to get registration under Section 12AA of the IT Act. That is the only question to be decided my lords. This is the only question. I am income tax assessee, I have a PAN card, and also that is I have a file return, I have also test, but they say that as because you have no your society is not registered under the Income Tax Act, that's why you are not eligible for exemption certificate under Section 2AA of the IT Act. And a similar case, and quoted in last annexure, my lord, similar society, the department has already given resident certificate, even though it is bylaws from the Washington.
And the question has been framed.
Yeah.
When?
On 18/12/2019. In item number 19 and 20/2019, where the institution of trust in India for grant of registration under Section 12A of IT Act is a precondition when the institution income tax assessee and the filing return which has been accepted by the department without any.
Which date did you say?
18/12/2019. Order number 22.
Where the institution of a trust for grant of registration.
Both are same. 1920 the same. It is converted to WPC converted to IT.
So he says it is covered in his favor. Is that correct?
Yes, ma'am.
Where is the judgment?
Judgment, it is
You say in another
another society they are giving it a annexure 4. Page 34. Indian Evangelical Mission at Kingston Road, Bangalore.
On 18/12/2019, while admitting both these appeals, the following question was framed for consideration by the court. Take from order number 319 of 2019.
Tribunal can leave the same.
It is pointed out that in respect of the Indian Evangelical Mission and Court Bangalore, which is similarly placed as the present appellant, it has been granted under registration under section 12 chapter A of the Income Tax 1961. Notwithstanding that
Tribunal order mechanism.
The tribunal says that he has not registered.
it will not be governed can be registered at section 12 AA, although it is not registered in India and it's not by India. Full stop. The above fact is not disputed by Mr. Chimankal and senior standing counsel for the department. Full stop. It appears that the tribunal did not notice the above fact. But proceed to uphold the denial of the registration under section 12 AA of the Act only on the ground that the SSC had income from sale of literature as well as sale of agricultural products, and that its activities are accordingly in the nature of single quote trade, commerce, or business, end quote. What do you say to that?
Well,
that you are engaged in trade, commerce, and business and not charitable activity. That's the finding.
that is not there, my lord. We are leper society, my lord.
No, but you're getting income from sale of literature as well as agricultural products, it says.
No, we are not dealing with those things, man. Where commissioner get it? And we are not business concerned, my lord.
Page 5 of the tribunal's order says
Tribunal only stated, my lord,
from
that
the income and expenditure account, a copy of which was filed before us, we noted that the SSC has income from sale of literature as well as sale of agricultural product. So this is the finding.
in reply to that finding, my lord, the sole object is not like this. So it is ancillary things. So ancillary object cannot be frustrated.
Apparent points out that main activity of the petitioner is to look after people suffering from affected by leprosy. And it may only be incidentally to that main activity that it earns some income from sale of literature and agricultural products. The considered view of the court, this could hardly be the ground on which the petitioner's request for registration under section 12 AA of the Act could have been refused. Paragraph. For the aforementioned reasons, the question framed is answered. In the affirmative. No, it's the answer to the negative by holding that it is not necessary for an institution of a trust in India no, it's not necessary for the appellate SSC to be an Indian institution for the purposes of grant of registration under section 12 AA of the Act. Particularly when it is an income tax SSC and is filing its return. which have been accepted by the department without demo. The impugned order of the tribunal and the corresponding orders of the CIT bracket A and assessing officer are accordingly. No, corresponding orders of the CIT. The application of the appellant under section 12AA of the Act are hereby set aside. The necessary orders granting the appellant assessee the registration be issued within a period of 8 weeks.
Both of these. 24. My lord, item number 24 may be taken up. 24 is question at page number 6, my lord. Whether on the facts and in the circumstances of the case, the assessment made under section 43 of the OVAT Act for the tax period 1/4/2007 to 31/10/2010 is valid and sustainable in the eyes of law, admittedly when no assessment was made for the tax period 1/11/2009 to 31/10/2010 under section 39 or 42 of the OVAT Act as required under section 43 of the OVAT Act. Case of automobiles, my lord, this is answered.
But the two periods do not strictly coincide. What happens then? For the period 2007 to 1/11/2009, what does one do?
My lord, the assessment period is 1/4/2007 to 31/10/2010.
Correct. Now, the second period where no assessment was made.
Wrongly typed, my lord. Wrongly typed. Sorry, my lord.
Okay. Okay. While admitting the present revision petition on 12th March 2018, the following question was framed for consideration. Then reproduce two questions. Paragraph. It is pointed out at the outset by Mr. Mohanty that in question number 1, the mention of the period as single quotes 01/11/2009 to 31/10/2010 unquote is a typographical mistake and should read as 1/4/2007 to 31/10/2010. Paragraph. Correct, is it? Assessment order. It is 1/4/2007. And this is the 43 order.
43 order, my lord.
But the self-assessment, we don't know for which year. So he says there was only a self-assessment for the same earlier. All right. In view of the judgment in Keshav Automobiles, as affirmed by the Supreme Court in Rati Steels, the above question is answered in the negative, that is in favor of the SSC and against the department. Paragraph. In view of the answer to question number 1, as a result of which the impugned order of the tribunal corresponding orders of the AC, ST and STO are set aside, there is no need to answer question number 2. The revision petition is allowed in the above terms.
Obligement.
Item number 26.
46.
May I please, Your Lords? There are two issues, two matters are connected.
One writ petition and one this.
One is IT appeal. Let me take IT appeal first. Thereafter, I'll take writ petition.
All right.
The Lordship in IT appeal, Lordship admitted the following question of law on 3/9/2021. Whether on the facts and the circumstance of the case, the Lord and Income Tax Tribunal is right in law in sustaining the order of the Commissioner of Income Tax Appeal 2 without any decision on merit in respect of jurisdiction of the assessing officer to complete the scrutiny assessment in violation of CBDT guidelines for the scrutiny assessment year 2010 and 11, published on 10/9/2011. Whether on the facts and circumstances case, the Land Income Tax Appellate Tribunal was right in law to uphold the findings of the Commissioner of Income Tax 2 on diversion of funds, 88,04,000 violation of provisions section 11(5) and 13(1)(d) of the Act, although appellant's case falls under section 11(1) of the Act. whether the facts and circumstances tribunal is right in law, confirm the addition of this 88,04,000, despite the advance is not investment or deposit as per section 1023C VI of the Act. Will not see if the question number 1 is affirmative.
Then other two questions will automatically follow.
Automatically. Will not see before coming to guidelines, I would like to place section 199(1)
Income Tax Act
and 199(2) of the Income Tax Act. Very important.
Yes.
May I please? 199(1). Board may from time to time issue such orders, instructions, and directions to other income tax authorities as it deemed fit for the purpose of proper administration of this Act, and such authorities and all other persons employed in the execution of this Act shall observe and follow such orders, instruction, direction of the board, but no such orders, instructions, and directions shall be issued so as to require an income tax authority to make a particular. Yes, ma'am.
What is the section?
199.
199.
119, my lord.
You kept saying 199.
No, sorry. So 11, sorry. Extremely sorry. 119. Jurisdiction, my lord. Extremely sorry, my lord. May I place again?
Repeat.
I read it.
Repeat.
Instruction to subordinate authorities. 119, subsection 1. The board may from time to time issue such orders, instruction, directions to other income tax authorities as it deemed fit for the proper administration of this Act, and such authorities and such other persons employed in the execution of this Act shall observe and follow such orders, instructions, direction of the board, that no such order, instructions, directions shall be issued so as to require an income tax authority to make a particular assessment or to dispose of particular case in particular manner, so as to interfere with the direction of the Commission of Appeals in the exercise of the appellate functions. Then very important is with subsection 2, 119 subsection 2. Without prejudice to the generality of the foregoing power, the board may consider necessary and expedient so to do for the purpose of proper and efficient management of the work for assessment and collection of revenue, issue from time to time, whether by of relaxation or any other provisions of section, including section 143, 144, 147, and 210, 211, general or special orders in respect of any class of incomes or fringe benefits or class or cases, setting forth direction or instruction not being prejudicial to the assessee as to the guidelines, your lordship mind, guidelines, principles, or procedures to be followed by the income tax authority, work relating to assessment or collection of revenue, or the initiation of proceedings for the imposition of penalty, or such other order as may board is opinion that it is necessary the public interest so to do so, be published and circulated in a prescribed manner for general information. The board, if considered desirable to expedient do for avoiding genuine hardship in any case or class of cases by general or special authorities, any income tax authority, not being commissioner.
Is it relevant?
Not relevant. Relevant is 2. Relevant is 2. In exercise of the powers conferred under subsection 2 of section 199, your lordship, if coming the factual aspects, then your lordship, I saw one judgment of the Honorable Supreme Court interpreted subsection 2 of section 199. You go back. 119.
So it's binding of the department, not binding the assessee.
Yes. That judgment is I have marked. Very important paragraph. Come to within 10.
No, but what's the consequence of breach of that guideline is the question.
Yes. That will not, they're bound by the instructions, guidelines.
That's true. They're bound. But what happens if they violate it?
Then
what is the consequence of not adhering to the guideline?
If guideline, then assessment will go.
Has it gone? Is there any judgment where assessment has been set aside?
Yes, has gone.
Which one?
In just
Yeah, because if it's a procedural infraction, simply has to go back.
I filed my counter at page 3 at part 10.
Just that when the guidelines are not followed, assessment have been passed, then orders have been quashed.
In what form did the guidelines not get adhered to? What did the guidelines require which he did not comply with?
That in guidelines clause A, G, annexure 1, there are 3 types of cases. Once a case is selected for CAS, CAS means computer assisted selection scrutiny. Automatically, all the cases will be scrutinized. Another case is certain criteria has been fixed. See, value of an international transaction as defined under section 92B exceeds 15 crore. Cash involving addition and earlier assessment in excess of 10 lakhs on substantial recurring deposit of law or fact which is confirmed in appeal or is pending before an appellate authority. Cases involving an addition of earlier assessment or issue of transfer pricing in excess of 10 lakh or more. Assessment in survey cases for financial year surveys carried out. The criteria will not apply if the following conditions are fulfilled. There are no impound of books or documents. There is no retraction of disclosure, if any, made during the survey. Declare income, excluding any disclosure made during the survey, is not more than declare income of the preceding year. Then, Your Lordship, assessment, source and seizure cases to made under section 150.
No, you're reading all kinds of clauses. Sir.
My important clause is G. G. Assessing officer may select any return. For scrutiny after recording his reasons and obtaining approval of the CCIT / DGIT. The case under this category should be selected if there are compelling reasons and case is not selected through CAS. CAS means computer assist. The case should be watched by the CIT in respect of the quality of assessment. This aspect has been dealt by the CIT appeal in page 55 of the CIT order. My Lord, page 56.
Yes.
No, page 55. Lots. That is also clause G. Here, the CIT held, he should have obtained the administrative approval from the Chief Commissioner of Income Tax. The appellant has argued along with the procedure that case did not fall under any of the criteria of selection of scrutiny as stipulated under the CBDT guidelines. Therefore, section cases for scrutiny is illegal and inconsequent. Thereof, the issuance of notice under 143 is illegal. The said guidelines of finance number 225-93-2009/ITA Roman 2, republished on 10/9/2011, themselves state that they are meant for use of officers of income tax department. It further stated that they are not to be disclosed even request to be made under the Information Act. In view of the decision of the Central Information Commission of the case, see Kamala versus Director, so and so, it is therefore clear that guidelines are not lookout of the appellant and may or may not be binding on the AO and can be employed by the appellant as a defense in case where it is offender. The notification circulars in instructions guidelines are recommended nature, whereas instructions and and analogous communication are to be followed. The selection of a given case or a set of cases for purpose of investigation and assessment is the prerogative of the department, and the officer are and beyond the purview of questions queries by those impacted. Many of the reasons are necessary in rational and public interest, confidential. It is true that the AO could have taken administrative approval, of the CIT, if not so obtained, to alien the selection of the case with civility guidelines. He himself observed he could have taken the administrative approval from the Chief Commissioner for Income Tax for manual scrutiny. Here there is no manual approval.
So the only thing is that he did not get the approval of the Principal Commissioner, Chief Commissioner of Income Tax.
Yes.
Then it only has to go back. Once he gives the approval, it can happen. If it's a procedural irregularity.
Because the assessment has been, here is 29/2021.
10/11.
10. The notice was issued, 143 notice.
Yes, what do you say?
Without jurisdiction, my lord.
Tribunal order is very important.
Tribunal order. I also place the tribunal.
Paragraph 6. We have heard the rival contention and pursued the material on record. The first argument emphasized by the learned AR respect of assessment order under section 143 of the Act is bad in law. In the case of selective scrutiny in cash, not the scrutiny guideline issued by the CBT circular. Learned AR drew our attention to page number 1 of the paper book, where guideline of the selection cases for scrutiny for assessment year 2021 and 2011 were disclosed. The AR submitted that the SSC does not satisfy any of the criteria. On the query of the bench with respect to clause D, the selection criteria is applicable to all the mentioned agenda. Assessing officer may select any written or for scrutiny after recording and obtaining approval of the CCIT, GGIT. The cases under the category should be selected if there are compelling reason and the case is not selected through CAS. These cases should be watched by the CCIT, CIT in respect of the quality of assessment. Then second, paragraph 7. On the second dispute issue notice of...
No. Please read on. Learned AR could not prove...
There is a lack of jurisdiction of the AO or does not have approval of the CIT for selection of scrutiny, except making the submission with supporting guideline. On the query from the bench why the case of the SSC does not fall under the clause G as discussed above. The explanations of learned AR are not convincing to us, and accordingly we are not inclined to accept the reason explained by the learned AR on guidelines.
What does that mean, sir? That's virtually, simply says it's not convincing to us. What does that mean?
It doesn't convey any meaning.
Clause G.
No, why does it not fall in G?
That has been mentioned in my counter in page number 3. The same, what the guidelines are meant for the use of department officers. It is confidential in nature and cannot be disclosed even in right of Information Act in view of the decision of Central Information Commission in the case of Kalman versus Director ITT CBT order number so-and-so 23/208. The appellant cannot challenge the legality of selection procedure of the department.
Why not, sir? Why can't the department be bound by it? Why can't the SSC challenge it? These are all just conclusions. There's no reasoning.
Yes. And more, the registration has been granted for the assessment year at page 67, 66, 67, 2011 to 1213 and 1314. VOG filed application on 17/5/2010. And after that granted, it has not filed for the 910 and 89. That is the dispute. That is a dispute for the IT appeal and the writ application.
Not writ appeal is different. IT appeal is
addition. Page 66 may kindly seen. This is to inform that the consideration to you an application received in this office on 17/5/2010 of a trust society institution, Navbharat so and so. Registration is granted with on 1/4/2010. And they have granted for 3 years. Assessment at 2011, 12, 1213 and 1314. only 8, 9 and 9, 10 years not filed any application before the competent authority.
8, 9 is a application for 1023 CBI, which is a REIT application before my lord. That has been rejected, relying on the judgment of the Uttarakhand High Court, and the Honorable Supreme Court has set aside the judgment of the Honorable Uttarakhand High Court, and this matter is now covered by recent judgment of the Honorable Supreme Court of India. Queen's Educational Society versus Commission of Income Tax regarding my REIT appeal. That I will come.
190. Binding on the department.
In all cases, Honorable Supreme Court said.
Need not. All right. First taking the appeal, ITF 59 of 2018. While admitting the present appeal on 3rd September 2021, the following questions were framed for consideration. Put down the 3 questions. First, question number 1 is concerned. It is relevant to note that the Central Board of Direct Taxes had issued guidelines dated 10th September 2011 under section 119, 2011, full stop. Inter alia, this concerns the selection of cases for scrutiny, full stop. As far as the appellant is concerned, the relevant clause of the guideline reads under, take the whole of clause G, which is in page 29. Paragraph. The specific case of the appellant assessee was that while completing the assessment under section 143 bracket 3 of the Income Tax Act, 1961 bracket Act, the assessing officer did not comply with the requirement of the above clause. Full stop. In other words, the prior consent of the prior approval of the CCIT or the DGIT was not obtained. Paragraph. The Commission of Income Tax bracket appeals dismissed the petitioner's appeal, assessee's appeal, by an order dated 20th February 2015, following which the appellant went before the Income Tax Appellate Tribunal, bracket ITAT, bracket, comma, Cuttack bench, with ITA number 163/CTK/2015. Full stop. In the impugned order, the contention that the assessment order stood vitiated for non-compliance with the mandatory requirement of the guidelines was negatived. On the ground that the authorized representative, bracket AR, bracket, of the appellant, open quotation, could not prove that there is lack of jurisdiction of the AO, unquote. And further, that the explanation of the AR were, open quotation, not coming to us, unquote, full stop. Paragraph, as rightly pointed out by learned counsel to the appellant. The guidelines which are relatable to section 119 bracket 2 of the Act were binding on the department. Full stop. The decisions of the Supreme Court of India in Commission of Income Tax versus Tamil Nadu Industrial Investment Corporation Limited, sorry, UCO Bank versus Commission of Income Tax, 1990, volume 237 ITR 889. And of the Andhra Pradesh High Court in Commission of Income Tax versus Srimati Nayana Dedia, 270 bracket 2004 ITR 572. bracket AP support the contention of the SSC that as far as the department is concerned, the above guideline is binding. Paragraph, there is no doubt that under the said clause in the guide, obtaining the prior approval of the CCIT for a scrutiny assessment was mandatory, and in the present case that was not obtained. Paragraph. The court is unable to agree with the approach of the ITAT that the SSC was required to single quotes prove, unquote, lack of jurisdiction of the AO. Stop when the undeniable fact is that prior approval of the CCIT was not obtained. Nothing more need to be shown to demonstrate that the guideline was not followed. Paragraph, for the aforementioned reasons, while setting aside the impugned order of the tribunal, this court quashes the assessment order dated 16th January 2013, passed by the assessing officer for the assessment year 2010-11. Then in the writ petition,
assessment date 10-11.
10-11, that's what I said.
Obliged.
In view of the above, question number 1 framed by the court is answered in the negative, that is in favor of the appellant SSC and against the department. In view of the answer to question number 1, there is no requirement to answer questions 2 and 3. The appeal is accordingly allowed. And then in the companion writ petition, you say the challenge in the present writ petition is to the order dated 14th January 2013, passed by the Chief Commissioner of Income Tax, bracket Odisha region, declining to accord approval for exemption in favor of the petitioner under section 10, bracket 23, capital C, bracket small 6, for the financial year, bracket F5, 2008-09. Stop. Paragraph. It is seen in the impugned order that reliance was placed on the decision of the Andhra Pradesh High Court in New Noble Educational Society versus CCIT 2003-34 ITR 303. Counsel for the petitioner points out that the said judgment now stands.
No, Uttarakhand High Court, my lord. Uttarakhand High Court.
Sorry?
Uttarakhand High Court. Uttarakhand High Court. CIT order, Uttarakhand.
But here it says Andhra Pradesh High Court. Just come to para 5.
Yes, ma'am.
Of the impugned order.
Para 5, no, my lord. Para 5.
Bottom of para 5. The reference is to an Andhra Pradesh High Court judgment.
No, ultimately, he relied upon the judgment of Uttarakhand High Court. I will show, my lord.
What was reversed in the Supreme Court according to you?
Your Lordship, Uttarakhand High Court held that if a educational society is making systematic profit or earning profit, and that profit is being utilized for the purpose of expansion of the educational institution by acquiring the assets like furniture, buildings, then Uttarakhand High Court held that it is for profit, not for existing for sole purpose of the educational institution. And they disallowed the first tribunal order. Then Honorable Supreme Court upheld the decision of the tribunal, but the tribunal held for existence of an educational institution, some capital expenditure is required to be incurred by an SSC, like acquisition of building, acquisition of land, acquisition of fixed and furniture and fixtures, etc. And Uttarakhand High Court says these are.
Sir, you're not praising the Uttarakhand High Court judgment. You're not placing the Supreme Court judgment.
I have already. Sorry, my lord.
Where is it referred to in the impugned order? Where has this been referred to in the impugned order?
Supreme Court. Uttarakhand.
So you are reading para 5.
Yes. I'm just reading Uttarakhand matter. Your Lordship may kindly see. Page number 6, internal page number 6. Internal page number 6, page 147. Similar issues are subject matter of judicial analysis by the Honorable Indore ITIT in case of MP Raja Open School Bhopal versus Deputy CIT, assessment year 3-4-289, and in order passed 8th November 2012, the Honorable ITIT had occasion to examine various judicial pronouncements relating to surplus of educational institution and the eligibility of such institution from charge of income tax. According to Honorable ITIT, Rule 2BC rules prescribe the educational institution where gross receipt in a year exceed ₹1 crore has to make application before IT authority seeking exemption under section 1023C. In a situation where surplus earned by the educational institution from its activities itself exceeds 1 crore. In other words, where surplus.
Sir, Justice Raman says this judgment of the Supreme Court has been disapproved in a recent judgment of 2020 Supreme Court. You may want to examine that.
I would want to examine.
Noble Educational Society.
Just examine Noble Education Society. The 3-judge bench of the Supreme Court.
No Bharat. Yeah.
Justice Ravindra Bhatt's judgment. Yes.
Or 2 bench.
No, there's a 3-judge bench now in 2022.
2020.
So just examine that.
October 19, 2022. Noble Educational Society. Civil Appeal number 3795 of 2014.
Yes, Lordship. I have not come across.
Yes.
So this writ petition alone, you keep it on board. Only the ITA is allowed. All right. This writ petition will stay on board, sir. 3670.
Next one. Your Lordship,
whatever, it'll stay on board.
I require some time, my lord.
Yes, yes.
To read the judgment.
Anyway, it will come next week, sir.
No, next week I will not be able.
It's all right. We'll accommodate. No problem. Yes.
In January.
Sir, we will not dismiss your. You can take it from us. We will not dismiss your writ petition. All right.
Obliged.
I don't know. 51.
51.
And the question of law, here page 10. The Honorable High Court has already admitted question number 1. Whether on the facts and in the circumstances of the case,
the tribunal was legally justified in reversing ITC to the tune of rupees 3,05,789 on the allegation of sale price being less than the purchase price without taking into consideration the provision of section 28A of the OBT Act, which provides.
STRB 58, no? But the questions are very different. Rukmani Motors,
my lords.
Yes, 13/8/2018 order.
2111, just see this. Oh, SS.
My lords, same.
Oh, that's the simply.
Same has been quoted here. My lord, court has quoted and directed the standing counsel to
take instruction.
Your lordship. Order honorable. Unless 31, right?
Order 9.
Your lordship, here there is a calculation, your lordship, that order is not with me. On merit, shall I argue, your lordship?
No, whatever, sir. We are not. There is a question put to you by this court in an order dated 27/11/2019. They've asked you to take instructions on.
My lords, in this case, the assisting officer has not followed 28A. The appellate authority has followed, and the tribunal don't 28A but has not followed the calculation. That is, calculation is in the rules there. Is available in the rules.
You should go back to the assessing authority.
Or to the tribunal, my lords.
Your lordship, your lordship may kindly turn to page 41. The first appellate authority has allowed his case in favor of the dealer, and the tribunal has reversed, and the first appellate authority allowed and taken a calculation, which is itself, there is a calculation error. Your lordship, prima facie.
There is a typical error, my lord.
Your lordship may kindly turn to page 41.
So should we go back to the tribunal then?
Tribunal has rectified that order.
No, my lord. Though tribunal has mentioned 28A, but has not followed the calculation as per the rules.
You mean to say that rule 14(6) ought to have been followed?
My lord.
That having not been followed by the tribunal.
By the tribunal.
In connection with 28A.
My lord.
That formula is given.
My lord.
Under rule 14.
My lord. That is annexure.
UVW.
Annexure 6. Also see page 9 of my revision petition. There I have mentioned page 8. I mentioned I have quoted the calculation. So whatever is coming, that is 10,910.
We'll send it back to the tribunal. Let it examine it, sir.
My lord.
You say the present revision petition by the SSC was admitted by this court on 13th August 2018, and the following question was framed for consideration. Paragraph. On a subsequent date, that is 27 November 2019, the following order was passed with this court. Paragraph. Having heard learned counsel to the parties, it appears to the court that the tribunal, in fact, has not considered the applicability of section 20(8) small a of the Orissa Value Added Tax Act 2004 (OVAT Act), read with rule 14(6) of the OVAT rules. Full stop. Although there is a mention of the probability, there is no discussion on its applicability. Paragraph may be noted here that the first appellate authority had accepted the plea of the SSC, but the tribunal reversed it in an appeal filed by the department. Paragraph. In view of the fact that the applicability of the above section 20(8) small a of the OVAT Act and rule 14(6) of the OVAT rules has not been discussed by the tribunal, this court sets aside the order dated 25th January 2018 passed by the Odisha Sales Tax Tribunal and restores essay number 203(5) of 2014-15 filed by the state to the file of the tribunal where it will be listed for directions on 16 January 2023, on which date the assessee will remain present through an authorized representative. Full stop. The tribunal is requested to dispose of the said appeal, preferably within a period of 6 months thereafter. The revision petition is disposed of the above terms. Please call it a day.
Get